Morning, gentlemen. How are you? Well, let's stay indoors.
I tried, it didn't work.
Yeah, sorry about that. Ms. Wood,
Yes.
can you rotate the podium camera so that it is facing the two deputies more so than,
Yes.
okay? Thank you. That's good.
Is that good?
Just don't break anything. That's good enough. All right. Thank you. All right. Ms. Rivers, good morning. Can you hear me?
Good morning, Judge. Good. I can hear you. Welcome back.
Well, thank you. Did you kidnap one of my plants?
I did. It's in the emergency room right now.
Okay, but it'll come back. Is it going to make it?
It is going to make it. It's actually doing a lot better right now.
So I'm not going to take that as a statement that it does better under your care than mine, but you will resuscitate it and then I'll get it back.
Yes, I'm doing some work on it right now.
Thank you.
Okay.
Appreciate it. All right, we're going to get started. Good morning, everyone. First day of August, me seeing you. We've got a bunch of calendars. We have two that are supposed to start at 9 and one at 9:30. Hopefully we can get through all that, give everyone a lunch break. And then we've got a couple calendars at 1:30. We're playing a little bit of catch up because Ms. Charles was on leave for a long time. And there was a judges conference this week. And I had to go to Alabama for a baseball tournament for my son that they lost. But we're back. Everyone's in school or will be soon. So it's time to get down to business. We have a trial calendar next week, pick a jury on Wednesday, and then we'll just make progress from there. It was good and bad hearing from other judges from around the state about how well or not well they're doing in terms of moving cases. So in the end, I think we're in a good spot and we'll keep up the work. We are having some turnover on the DA's side. And hopefully that doesn't disrupt things too much. Ms. Charles will become someone else. We may get that name today. Mr. Thomas, my understanding is you are moving to another division. You may be in the same unit, but you'll be in different courtrooms. Mr. Whitenauer will become the Mr. Thomas. And then we're getting Mr. Brown, but you're not Mr. Brown. You're Mr. Kaufman.
Mr. Shapiro. Judge.
Mr. Shapiro. What unit? I just need to know the roster. So you aren't leaving this division?
I am not. No, Your Honor.
And you are handling the cases that who used to handle?
It's crimes against children. So I believe
Ms. Patel?
Ms. Patel. Yes.
Who's going to the gang unit, but
Correct.
Mr. Hiles is staying here. He's on the call, I think. Hey, Mr. Hiles. So Mr. Kaufman will be, did I just say it wrong again? You're Shapiro or Kaufman? I need to write it
Shapiro,
down.
Judge.
You're Shapiro, okay.
Fine.
I don't know why I had that down. Now it's written down. Mr. Shapiro will be handling our crimes against children cases that Ms. Patel used to. And did Ms. Patel's last name used to be Yelam Raju?
Yes,
Okay, so for example, you have Mr. Tutman.
I do.
Okay. And that's Shapiro. I'm gonna write that down for that case. So you haven't gone anywhere. Mr. Brown is the new, who is he replacing? Mr. Whitenauer, because Mr. Whitenauer is sliding across units. I hope you guys know someone named Seth Brown, because I've been told Seth Brown is coming in here to handle cases for the DA's office for one of the 19 former CWAC units.
Yes, sir. So he'll be handling these sexual assault cases.
Okay, so an alleged rape against an adult victim, that's Seth Brown. Got it. A domestic violence case was Travis Thomas, soon to be John Whitenauer. Seth Brown is handling what John Whitenauer was, and Ms. Hall was filling in for Mr. Whitenauer. Got it. And Mr. Shapiro has child victim sex case. So if a child is murdered, you don't have that unless the child was murdered in connection with a sex crime, or you might not have it anyway because it was a murder.
No, Judge, for any child under the age 16, it's my understanding that our unit would handle it.
So you are handling the Michael Reynolds case that is specially set going to trial, or I think Ms. McCauley's keeping that.
Judge, I was just given the list of our cases in this courtroom, so if I can check that real quick, I should have an answer for you.
Okay, I'm not putting folks on the spot. I'm just,
No.
I've been away for a while, new names, all that. I think Ms. McCauley is holding on to that. She's the one who filed this motion saying you better special set it.
Okay, I do not have Mr. Reynolds on my list, but I can check in with Ms. McCauley and
Okay.
update on that.
Your Honor, I know Ms. McCauley's keeping that. I've just, we were bouncing ideas off of each other last week, so I know she's planning on keeping that.
Okay, she's wanting the gang angle to the Michael Reynolds case?
No, I think it's, just somebody outside of that unit.
Okay, got it.
Sometimes you get the tunnel vision.
That's right. Okay, well, let's get started. Why don't we do the inquiry calendar first, unless someone has someone here in connection with bond, and it's super, we'll do those this morning, but all right, we'll do the inquiry calendar. Our first position is Mr. Robinson. Was he brought over? We have Tyrone Robinson.
Yes, sir.
Can we bring him out, please? Mr. Granums, have you met with Mr. Pritchett yet?
No, Your Honor, I have not met with Mr. Pritchett. We're still waiting to receive discovery in this case. And so I was waiting until we got that, so I would have something tangible to speak to him about.
Okay.
I'll send that today. I didn't realize that you were gonna, maybe I was just confused with all the attorneys switching, but I'll send that to you today via Dropbox.
Okay, Mr. Robinson, you can come up to the podium, please. All right, good morning, Mr. Robinson. How you doing?
Good morning. I'm doing good.
Good. We are still trying to sort out who's going to be representing you. You had Beverly Taylor. She withdrew as your lawyer. And I'm not remembering the last time you and I spoke what you told me about whether you or your family are planning to hire a different lawyer, or if you need me to make sure a lawyer gets appointed to represent you.
I need a lawyer appointed to me.
Okay. So you've talked with family members. It's not in the cards for people to hire anyone.
No.
Okay. Good to know. Ms. Wood or Ms. Feely, do you know if your office is conflicted off? There are two co-defendants who've had private counsel, I believe, always. Mr. Pritchett has had lawyers. I just don't know if it was ever with your office, and thus that would make it not possible for your office to represent Mr. Robinson.
Judge, I did. I confirmed before today, we represent two of the alleged victims in this case.
Oh.
They have open cases with us right now.
Okay, got it. So regardless of any connection your office may have with Mr. Pritchett, folks who might be testifying as having been victims of the home invasion, your office represents.
Yes, Judge.
Okay. Mr. Hiles, is that your understanding?
I didn't know that.
I'll send you an email. Mr.
Just send
Howe.
me an email, please. That's fine. I can see kind of how that would make sense.
Well, I mean, it makes, if they represent one of the victims, it's not a
No.
makes sense.
No. What I'm saying is makes sense is I would think any of the victims would have probably, if they were for what they were charged with, unrelated, would have been able to hire private counsel, just knowing where they came from.
Okay. Well, it'll be a good idea, I think, to chat with Ms. Wood, but that means for Mr. Robinson, we need to find C3 representation. I assume, was the conflict defender ever representing any of these defendants, or ought we to reach out to Mr. Cladis?
I believe when I looked at the first appearance action for Mr. Robinson, I believe it had a C3 listed, but I
Okay.
can double check that.
Okay. I should get Odyssey open. Mr. Robbins, I'm sorry to keep you standing right there. I just want to make sure we don't false start and line up a lawyer for you who then says, I can't represent Mr. Robinson because there's a conflict. You cannot have a lawyer from the same, I'll call it firm, but could be office, that represents one of your co-defendants. So if Mr. Pritchett had someone from the public defender's office, then you cannot have someone from the public defender's office. It sounds like whether he did or not doesn't matter, because some of the alleged victims in your case, they have had their own legal troubles and the public defender's office has represented them. So they're out. Then we turn to what's called the conflict defender. They pick up when there's a conflict like this. And I just need to see if that office has represented, it's okay if they've represented you, but did you have Ms. Taylor from the very beginning, or did you have another lawyer originally?
I had another.
You had Ken Shepard.
Yeah.
Okay, which would mean you had a C3 lawyer. Okay. Wonder what the conflict defender issue was. All right, Mr. Granums, do you have any news for us about additional C3 resources? I know that's a level above you, but you're at least in that network.
Well, Your Honor, I'm actually assigned to GPDC's complex trial team. And so what we've done is we have stepped in to handle or to agree to take some cases where there were C3 issues, but we're not technically C3 attorneys, if that makes sense.
Okay, no, I understand that. My question though was whether you happen to know if your ranks are growing. Ms. Upshaw was someone else who was doing the good work you were doing, and she has stopped doing that good work. So there's a case on one of my calendars today where I assume there's going to be no lawyer for that defendant. And we need to fix that. We certainly need to get a lawyer for Mr. Robinson. And that's not your responsibility. I was just wondering if you were aware, oh yeah, actually there are 5 more Mr. Granums who are going to be helping out in the way you are with complex cases.
Yes, Your Honor, there are. And we are adding to the staff in this office. It is newly created. As far as Mr. Robinson is concerned specifically, he would still be a conflict with this office. So I'm not sure how that would be handled.
Okay, well, I'm not sure what you mean by a conflict with the office. Before we might get Ken Shepard, C3 attorney, and then we would get who's the guy in the gang unit now? Roderick Bridges as a C3 attorney. And they were all C3 attorneys, but maybe that's different from what you're describing because of the nature of your employment with GPDC.
Well, to the extent that there would be co-defendant for Mr. Pritchett, all of the attorneys in my office are part of the same team, part of the same office.
Okay. Well, we'll need to work through it. I recognize that you aren't the person who'll be representing Mr. Robinson since you represent Mr. Pritchett. All right, Mr. Robinson. Ma'am, did you have something you wanted to add in Mr. Robinson's case? You were raising your hand. Yes, you. Good morning.
You and I spoke on June the 27th. She got a call saying it pushed all into 30 more days. I was wondering why.
You're here, why?
I was wondering why my son was not allowed to be here today.
Who's your son?
And the Sanchez, Lord.
Okay, not Tyrone Robinson. We'll get to that. All right, thank you. All right, Mr. Robinson.
Your Honor.
Yes.
So the conflicts with the putting in C3s, that goes back to representation from the case that Mr. Pritchett was revoked on.
Okay. Got it. Okay. We're going to keep working on this. We will not bring you over here again until we've got that lawyer for you. Okay. Better yet, we'll get that lawyer to come see you.
How long that gonna be?
If I had an answer, I'd give it to you. We are working through an unacceptable crisis and you're not the only one. Whoever Ms. Upshaw represents is going to not have a lawyer anymore because she doesn't represent him anymore. So we need to fix this. It is top of mind for the courts, but I don't get to hire the lawyers. There are other agencies that are supposed to be getting this done. Meanwhile, you're stuck in jail. So
What's going on with this bun? I'm trying to figure out why I got an $850,000 bun.
can you say that again?
I said, what's going on with this bun? I'm trying to figure out why I got an $850,000 bun.
Well, you got a big bond, you had big charges. I don't know what Ms. Taylor did with that, but without a lawyer, you can't work through bond issues. So we need to get you that lawyer, and we'll do what we can. Okay?
Yes, Sean.
Thank you.
Your Honor. So I do have a motion to suppress at 9:30 in another courtroom. Is it okay if I go handle that and then come back?
What do you have on this morning's calendar?
We'll have an inquiry, number 5. It's just an inquiry. And then on the other calendar, the bond hearing, actually, no. The status, the 9:30 status calendar, I have position 8.
Well, I guess what you can do is let a colleague know what's going on with that case and what's going on with position 5 as well. Because we'll work through those and someone from the DA's office needs to be able to provide a perspective. Okay?
Yes, sir.
I'm happy to do number 5 next, if that helps.
That'd be awesome. Your Honor.
Okay, why don't we do that? So who is representing? So it says Ms. Charles. This is Keith Berry we're talking about?
Yes, Your Honor. This is a DV case.
All right. And who represents Mr. Berry on the defense side? Is Ms. Johnston a public defender?
I believe so, but it is my case, Your Honor.
Great. Do you want Mr. Berry to come out?
Well, he can. It should be relatively short though, because he has a probation matter this morning in another courtroom, and he also has a CP case. So I spoke with him at the jail this week, and I think we would like to work towards a global resolution of this case and the CP case and the probation if we could.
Okay, let's bring Mr. Berry out and have that short conversation. Mr. Berry, you come on up to the podium, please. Good morning, Mr. Berry. I'm Judge McBurney.
Good morning, sir.
How are you?
I'm okay for the most part.
Mr. Berry, you have a case that's assigned to my division that charges you with aggravated assault. You missed court for some reason, and I signed a warrant because you didn't show up. In the meantime, it sounds like you may have picked up a probation situation that I think you're going to go talk about today. You also have an unindicted case. Ms. Feely from the Public Defender's Office was just sharing that with me. She would like to spend some time with you to see if there is a way to work everything out, to take care of probation, these new charges, and this indicted case. It doesn't sound like you'd be going anywhere because of those 3 things at once. I don't think folks are going to be real interested in talking about bond as opposed to let's try to wrap everything up. Is that a fair, I mean, you may be interested in talking about bond. I will be less interested, Ms. Feely, but did I fairly summarize your objective to see if there's a global resolution to probation, this open case and the unindicted case?
Yes, Your Honor, because he is being held without bond on the CP case. So we do want to try to work everything out together.
The CP case involves what kind of charges?
Same.
Okay, same victim?
Yes.
Okay. Mr. Thomas, this case will be transitioning from you to Mr. Whitenauer. Anything you want to add at this point?
So, Your Honor, I do know discovery was served on Kate Johnson back in June. So I guess Mr. Whitenauer is going to get with Ms. Feely to make sure that everything transferred over and that she has everything that we have. And then I also have on notes that there needs to be a plea and arraignment. I'm not sure if you're tracking that, Your Honor.
Let's look.
So I think the court that he missed was the plea and arraignment.
Yes, thank you for flagging that. So Ms. Feely, I think it would be helpful for purposes of moving this case along, not to rush anything, but just to ensure that this case is moving in case the CP case is dismissed or get to loggerheads on that we handle the arraignment. So if you need to talk to Mr. Barry real briefly about that, that'd be great. But I want to know if he wants to be formally arraigned or if he's waiving arraignment. You can fill out that magic form. That way we can get a scheduling order, and that'll just keep us nudging you and Mr. Whitenauer to try to make all the things happen that you're trying to make happen.
We would waive formal arraignment and or plea of not guilty at this time, Your Honor.
Okay. So Mr.
I'll
Barry.
fill out the appropriate paperwork.
Sure. Mr. Barry, Ms. Feely will fill out a form on your behalf that basically says, right now I'm pleading not guilty. You can always change that if you're working the case out. But that'll allow me to set some deadlines in the case, make sure that you and your lawyer get all the discovery. If we need to have a motion, maybe you said something to the police that should be suppressed, or at least your lawyer wants it to be suppressed. We would have a deadline for that kind of hearing. It sounds like the goal here is to negotiate something that addresses everything. But Ms. Feely needs a chance to be able to. One second.
You did his verification, but I don't have it in his insurance.
We got a lot of folks who somehow got this Zoom feed, which isn't how it's supposed to work. I'm going to give you and your lawyer a chance to have those conversations. As soon as Ms. Feely thinks you're in a good spot to maybe work something out, we'll get you back in here and we can do that. It's not a waiting game. Unlike poor Mr. Robinson, you've got a lawyer and there's a lawyer on the other side. So we'll keep it moving. Ms. Feely, anything else on behalf of Mr. Barry?
Not at this time. Thank you.
Mr. Thomas, anything else?
Not this time, Your Honor. Thank you.
Okay, thank you. You'll let Mr. Whitenauer know when do you two transition?
Today's my last day, Your Honor.
Today, well, all right. I don't know if you'll be back for the other matter, if someone's going to cover that. It's been nice working with you. Let Mr. Whitenauer know he needs to connect with Ms. Feely.
All right, thank you, Your Honor.
All right.
And then, Your Honor, I also see Mr. Ortiz is already on the call. I know he's a 9:30 calendar, but it's just a status from what I understand.
The 1:30 calendar?
9:30 calendar. 9:30 status calendar is number 8.
Yeah. Hi, Judge. This is Zach.
You've got I guess a bad connection, kind of hard to hear. Can you try that again?
Judge, can you hear me?
Sort of.
Is it choppy?
Yes.
I'm here for Mr. Ortiz on the
All right.
9:30 status.
Do you work with Glenn Cooper?
Judge, I do.
Okay. Do you have the discovery?
Yes, Judge, we have received discovery. We recently retained a forensic psychiatrist to assist in the case. It took a while to retain him. He's retained now. So I'm going to ask for 90 days, if that's possible, Judge. Additional 90 days.
90 days for what?
To allow the forensic psychiatrist to prepare his analysis and his report.
Were there any motions filed in the case, Ms. Nelson? Yeah, we jumped around a little bit, and I can look. I just wasn't sure. It didn't say on. Oh, okay. Is this the gentleman who maybe sold a car or was operating a vehicle somewhere near the alleged victim, and folks got a little spun up about that, understandably so, but then you all sorted that out without needing to have a hearing?
That's correct.
Okay. So really the next stop for this case would be a trial calendar. And what you're asking for, Mr. Scher, is to have that pushed out a little bit so that the expert that you all have retained can do whatever he or she needs to do.
That's correct, Judge.
All right. So what I think I'll do is get this on, I don't have dates, so I can't give you a specific, but an October-ish trial calendar. That's not 90 days out, but it's not next week. And we'll see how that goes. But I want to ensure that the case is moving along and that we aren't going any more slowly than we need to. Does that sound like an okay next stop for Mr. Whitenauer, Mr. Thomas?
Yes, sir, there shouldn't be a problem. I also do want to put on the record, we have served all discovery that's on hand. However, the more we talk with the victim and go through everything, we're getting more discovery from the victim. So as I get that, I will continue to turn that over to the defense.
What's an example of discovery that's other than we spoke with the victim and she said X, so you provide a summary of?
It's more 404B type discovery.
Okay.
So
other incidents.
Stuff like that.
Okay. And as those you learn about those you share.
Yes, Your Honor.
Okay.
Sorry, Judge, just repeat that. I'm having choppy audio. I heard what's an example of additional discovery, and then it just chopped out.
Yeah, you've got a bad connection. There's 404B that is developing, or 414 or 413. It sounds like other bad acts evidence that the state is learning about the more they speak with the alleged victim in this case. And Mr. Thomas is saying that as that develops, he is supplying it to the defense. For your information, Mr. Thomas will be rolling off this case when the sun goes down today, and a different ADA will be handling it going forward, John Whitenauer. I will put this on an October-ish trial calendar, and we will take it from there. Mr. Scher, anything else?
I appreciate it. Best of luck to you, Mr. Thomas, and thank you, Judge. I appreciate your time.
All right. Mr. Ortiz, were you able to hear all that? You can just put thumbs up. Mr. Ortiz? Yeah, you're muted, sir. That's all right. All right, Mr. Scher, you're free to go.
Thank you, Judge. Thank you, Mr. Thomas.
Thank you, Your Honor. May I be excused until the 1:30 calendar?
Yep.
Thank you, Your Honor.
All right, back to our regularly scheduled inquiry calendar. So Mr. Granums, I'm going to ask you to make it a priority to meet Mr. Pritchett. I'm not going to bring Mr. Pritchett out here. I think after you meet him, you'll understand why. Mr. Hiles, you will make discovery available to Mr. Granums next couple business days.
That's correct, Your Honor. I'm good on that.
Okay.
Thank you, Your Honor.
Yep. Will you do your best to connect with Mr. Pritchett in the near term?
Yes, sir.
Okay. And then I guess we'll put it back on an inquiry calendar a few weeks out to see where you, Mr. Granums, and Mr. Pritchett get with your relationship, and we'll go from there.
Thank you, Your Honor.
Okay.
Thank you, Your Honor. That's concludes my business for today. May I please be excused?
Yes, sir.
And
Thank you.
the same for me for this calendar, at least, Your Honor.
Yes, sir.
Thank you.
Jarvis Hillman.
Yes, Your Honor, he's in custody, and Miss Patterson from my office has joined the Zoom to update us on what we have in the works for him.
Okay. Ms. Charles, is this your case now? Okay. Let's bring Mr. Hillman out, please. Hey, Ms. Mansfield, I need you to mute your phone, okay? Thank you.
Good morning, Your Honor.
Hey, Ms. Patterson. Mr. Hillman, come on up to the podium, please. All right. Mr. Hillman, good morning.
Good morning, sir.
In May of last year, so over a year ago, I signed an order that required you by February of this year to attend 2 NA meetings a month for 6 months and schedule an appointment at Grady, at a particular place, to see some doctors and maybe see if any medications would be prescribed to help you work through some of the things you were working through. Those deadlines have passed. I think we couldn't find you for a while because I signed a bench warrant. You're here now. And Ms. Feely, who's the lawyer now handling your case, and a colleague of hers, Ms. Patterson, who you're going to see on the screen in front of you, are going to give me an update as to what's going on with your case to see if maybe we can still resolve it in the way that I think your lawyer and you were hoping, or if instead the state's going to need to say, we gave Mr. Hillman a chance, but we're going forward with his burglary. Okay. So let me hear, Ms. Feely, why don't you take it from here?
Sure. So we are still hoping to get this case, my case, resolved in the way that was originally planned, but he also has a 22 SC case. And so we're working on getting something in place that will allow him to get his feet underneath him when he gets out, and so he can complete the requirements. And Ms. Patterson can speak in more detail about that.
Okay. And it looks like the 22 SC is in non-complex right now. And okay. It's moving forward there. There was a scheduling order entered a couple days ago. But we would maybe globally resolve. I can always pull a non-complex case into here if we need to do that. Ms. Patterson, tell me, good morning, and tell me what you've got maybe in the works for Mr. Hillman.
Sure. So Mr. Hillman was interviewed by Georgia Works. However, he was denied. Having the information that you just presented about what your previous requirements are allows me to work in a different direction to make that direct connection to Grady. What I will need to do is just get updated records from the jail to just kind of take a look at the medications or if he's being prescribed anything at the jail, and then we can go in a different direction as far as what treatment would look like. I have also reached out to the social worker in the 22 SC case, and she also is working to get some placement options for it. So the plan is to actually collaborate with the social worker in the other case, and together I am sure we will come up with an appropriate placement for Mr. Hillman.
Was there a reason that Georgia Works said no thank you, that you're at liberty of sharing, just so I can understand what Mr. Hillman is working through, or is that not something we should talk about?
The interview, first, I was not aware that Mr. Hillman had already been at Georgia Works before. However,
Okay.
that was not the reason for the denial. They just felt like he was not ready for the program.
Okay. So Mr. Hillman's going to stay put for a little while longer while you, Ms. Patterson, work with your colleague who is working on Mr. Hillman's non-complex case to see if you all together with Ms. Feely can develop a program for Mr. Hillman that maybe the district attorney's office would think is sufficient such that these two cases can be resolved.
That is correct. I do have a question for Mr. Hillman. Have you gone to Grady before? Have you ever received any services or anything from Grady?
Yes, ma'am. When I got shot in the foot.
Okay, just medical?
Yes, ma'am.
Okay.
How's your foot?
It's doing fine, Judge.
Good. Ms. Feely, is your vision tentative that these two cases would sort out by way of a plea or some other format?
Or potentially a pretrial intervention kind of situation. So it may be that we can, with the district attorney's office consent, just present the court with an order at some.
A second PTI. Okay. And that would address the non-complex case as well.
That's my goal, yes.
Okay. All right. So what should we do in terms of next steps for Mr. Hillman? So we don't lose track of things. Have him on a calendar again in 2 weeks, in 30 days? What makes sense, knowing that you're going to be in trial next week and all that?
I wouldn't want to put it out further than 30 days.
Okay. We'll do 30 or less.
Thank you.
Ms. Patterson, does that give you enough time to coordinate with your colleague and tap your resource network?
Yes, sir.
Okay. All right, Mr. Hillman, do you have any questions about what we discussed?
So I understand what you were saying about sitting in jail 30 more days, but I've been trying to get in a program called Better Works Ministry inside the jail also, and one of the colleagues in jail told me that would be a good spot for me also.
Good. Well, you know what? Getting involved with a program like that is the kind of step you could take that then your lawyer could share with the prosecutor saying, look, Mr. Hillman is trying to do some things to better himself and maybe address some of the issues that caused this case and your new case, et cetera. So I encourage you to get involved with programs. I think what Ms. Patterson is looking at is programs on the outside, because the goal, of course, is to get you out of jail, but in a way where you're getting the support you need so that you don't get back to jail in 6 months because something else happens. Okay? So we'll see you soon. Ms. Feely, I didn't ask you about Mr. Barry when you'd want to see that reset.
I can be in touch with the district attorney's office, Your Honor, about the CP case and see and negotiate with them. And
Okay, and then just let Ms. Nelson know?
Yes.
Okay. We will probably reset it 60 days out just so it's in the system somewhere. And you can fast forward that as much as possible if you and Mr. Whitenauer sort something out.
Thank you.
So the last position then would be Willie Williams. I know Mr. Pritchett wants to come out. We'll do that. We may not do that right away. Mr. Granums has already left, but I got that note. Thanks. Mr. Williams, that is Ms. Charles's case, and who from the public defender's office?
It'll be mine, Judge.
Great. All right. Anything we need to talk about before we bring them out?
No, Judge. Ms. Patterson is also working for placement for Mr. Williams as well, and he's been advised of that, so it should be quick.
All right, let's bring him out, please. Does he have other cases, or his only reason for being in was the failure to appear?
I'm only aware of this one, Judge.
Okay.
And speak clearly when the judge asks you questions, okay?
Yeah. Okay. Good morning, Mr. Williams.
Good morning.
How are you?
Fine.
Good. Mr. Williams, you missed court a while ago, so I signed a warrant. You've been picked up on that warrant, and we are going to talk a little bit today about next steps. It's my understanding, but I'm going to let Ms. Wood, your lawyer, tell me more about it, that she and a colleague of hers, who you're going to see on the screen in just a moment, are looking for a program maybe that you could plug into when you get out. We're going to talk a little bit about that and whatever the next steps are. Okay. Ms. Wood?
Thank you, Judge. So primarily when I reached out to Ms. Patterson, the main concern was housing. However, after I met with Mr. Williams this week, there's some additional concerns. And so I did share that with Ms. Patterson. So I don't know if that new information changes how much time Ms. Patterson would need. But yes, I have shared with Ms. Charles kind of what my goal is. So Mr. Williams understands and is on board with that, Judge. So we're just looking for a reset date so we can have the program and then resolve.
Got it. Ms. Patterson, how far out should we set Mr. Williams's case so that you have enough time to try to line up some of the resources that Ms. Wood now appreciates we might need?
30 days should be sufficient.
Okay. So, will you be meeting with Mr. Williams? Should we let him know that you'll be talking with him, or you've already done so?
I will be meeting with you. Mr. Williams, I will be at the jail on Monday, and I will see you on Monday.
Okay. So Ms. Patterson works with Ms. Wood. Ms. Patterson is the source for resources. And so she needs to get to know you a little bit more so she can figure out what's a good program that might provide good structure, roof over your head, things like that. Maybe connections with medical care. Who knows? Actually, the answer is Ms. Patterson knows. But she needs to meet you. She's going to do that on Monday. She and Ms. Wood will talk more. Ms. Wood will talk with the prosecutor. And if they can work something out, we'll get you back here to try to take care of that. Okay?
Not today. So resetting for 30 days and then we'll have another court date. Okay? Okay.
Oh, hold on. Don't go anywhere yet. This is one that needs an arraignment. Okay.
Oh.
Let me. Yes, we ought to do that. So it's an old case. I guess it took a while to indict, took a year to indict, and then there was never an arraignment. So are you waiving arraignment on behalf of Mr. Williams?
Yes, Judge, we'll waive and our plea of not guilty and I'll get that paperwork done today.
Great. We'll get the scheduling order out, but it sounds like well before, other than the discovery deadline, you all may have sorted something out. Good. Mr. Williams, do you have any questions for me? Other than when do I get out?
Yeah, when do I get out?
You get out when you and Ms. Patterson and Ms. Wood have come up with a proposal that the district attorney's office thinks will keep you safe and keep the community safe. If they disagree on that, then we can get you a trial and you can go to trial on whatever this case is about. The allegation is you assaulted someone. I don't know who that someone is or anything about it. I may learn about it because you're entering a plea. It may be that the state says you don't need to plead. We're going to do a diversionary case. It may be you go to trial, but I will see you in less than a month to talk about that next step. Okay. All right. Take care.
Thank you, Judge.
All right, our bond hearings. Mr. Abate, you have one, you have two, and Mr. Shapiro, you've got one. Is there a particular order? We have an attorney on Zoom who is here only for that. So my suggestion is we do Mr. Mansfield first, but if that you guys have sorted it out some other way, we can do it a different way. All right. Can you pronounce your last name for me, please, counsel for Mr. Mansfield?
Good morning, Your Honor. Happy Friday. My last name is pronounced Ebot Tabi.
All right, Mr. Ebot Tabi, you ready for me to bring Mr. Mansfield out?
I am, Your Honor.
No?
I am.
Okay,
ready.
Hold on. Did they waive his appearance, or because he's a juvenile, he's not here yet, or?
Aware that he was not transported. The production order did not go.
Okay.
And so they were not aware. So the attorney is not aware.
Okay. Mr. Ebot Tabi, Your client, Mr. Mansfield, was not produced today. That is a administrative mistake. It's nothing you failed to do. It may be that people didn't realize he was a juvenile. But we can still have the bond hearing if you want to waive his presence. If you do not want to waive his presence, which is 100% okay, if that's your choice, then we can reset this into the very near future. But regrettably, Mr. Mansfield was not brought over. This happens sometimes with juveniles because our system doesn't do a great job of putting up a flag. So the sheriff goes to the jail. Mr. Mansfield's not there. He shouldn't be there. He's a juvenile. And so here we are. Tell me your preference. Do you want to still have the bond hearing, or were you expecting Mr. Mansfield to be a particularly active participant in the process?
No, I do not. I would go ahead and waive his presence. He's been there for too long. The earlier we can get the ball moving, the better.
Okay.
But before we proceed, if you don't mind, there's a few issues I'd like us to, if you would mind, us to pre-try.
Okay, well, let me do this. Let me get things on the record. So this is position 1 on our bond hearing calendar. It's 22 SC 181494, State versus Jason Mansfield. Mr. Abate is here for the state, and Mr. Ebert Tabai is here on behalf of Mr. Mansfield. Mr. Mansfield is not present virtually or otherwise. Mr. Abate is present in court. Mr. Mansfield's lawyer is appearing virtually. And you, sir, on behalf of Mr. Mansfield, are waiving his presence for today's proceedings. Is that correct?
That's correct. I don't intend to call him to testify or anything, so we can dispense of his presence.
Okay. And you had filed a motion for bond, which is the main thing that we'll do this morning in connection with Mr. Mansfield's case. But you also mentioned there were a couple other issues that you wanted to bring up, and you wanted to start with those. So why don't you share those with me and Mr. Abate?
Actually, we filed a motion for bond earlier in the year, which you heard, and granted bond. The amount, as you said then, was that it has to reflect the crime, but he's not been able to make bond. So we filed a motion for reduction of bond. So actually what we're here for today is our motion for reduction of bond, Your Honor. It's not actually a motion for bond. On the other issue, is where I just need to get the state to let us know whether they are still committed to, because earlier on too in the process, we talked about the likelihood of transferring this case to juvenile court. I've tried to call the state. I've not had any luck getting a hold of anybody. And I don't know if it's something the state is inclined to, because that would influence the conduct of our defense. That was what I was trying to get the state to actually to elicit from the state what was their posture with regards to that issue.
Okay. Anything else?
For now, no, just that.
Okay. I heard bond argument apparently in
February
of this year, and set a bond of $50,000 for Mr. Mansfield. At that time, there were only 2 charges. So that bond order doesn't work so well anyway, because after that, he was indicted and there are additional charges. So at a minimum today, I will need to set a new bond. It may be that same dollar amount. It may be less based on what you share with me, counselor. But his current bond order would not get him out, even if he posted the $50,000. And he actually needs to post 10% of that through the sheriff's 10% program, because it only addresses 2 counts in the complaint, and there are now 5 counts in the indictment. That's fixable. I'm not worried about that. Your second question It's a great question. It's not one that we'll resolve today. I'll ask Mr. Abate if he wants to say anything on the record about that, but I think ultimately, as you pointed out, Counselor, that's a discussion for you to have with Mr. Abate. Sounds like maybe the two of you haven't connected. You've had trouble connecting. I know you're both busy, and that may be part of it. Mr. Abate, what I heard Mr. Mansfield's lawyer ask is whether there is the possibility that this case could be redirected to juvenile court for disposition there. Something you want to talk about here, or something you'll talk about with Mr. Mansfield's lawyer, not in public setting?
We can probably talk about it outside of the courtroom at a later date. I will handle the hearing today, but this is actually it was supposed to be assigned to the Crimes Against Children unit. So it's going to be Mr. Shapiro, but I will handle it today. He may have not been able to connect with Ms. Patel. She's been in a couple trials the last couple of weeks, but I will either myself or Mr. Shapiro will contact counsel the next couple of days.
And
Okay.
Judge, I'm sending an email to Mr. Ebotabi right now with my contact information, let him know he can reach out to me regarding that.
Great. Mr. Ebotabi, did you hear that? Mr. Shapiro, who you can see, I think.
I saw him, and I appreciate that.
Yep. So that's your point of contact. If you have trouble reaching him, and I don't think you will, based on my experience with Mr. Shapiro, despite not remembering his name, is that he'll be very responsive. And you should reach out to my staff if you're having trouble connecting. But do contact him, and the two of you can discuss whether this is a case that's going to stay here in my division and in Superior Court, or instead go to juvenile court. In the meantime, it is here, and we should talk a little bit about bond. So why don't you share with me, Mr. Ebotabi, what you think I ought to hear that is different from before? Because if the only change circumstance is that time has passed, I don't know that I'm going to think that the dollar amount was inappropriate based on the seriousness of what I heard about at that hearing. But I'm open to listening to what you have to share.
Well, Your Honor, thanks again for the opportunity, and may it please the court, Your Honor.
I'm going to pause you for 1 second. I've got a Jason Mansfield on the call. That wouldn't be him patching in from YDC. That would be a relative with the same name, or a supporter who is indicating he or she supports by using the name.
I'm dead. It's Jasmine.
Okay.
Jasmine, the dad.
His dad.
Yeah.
Got it. Okay, great. You guys are welcome to be here. Just wanted to, if we had the chance to have Jason Mansfield Jr. Connect, just want to make sure that happened. All right. I'm sorry, sir. Keep going.
Thank you, Your Honor. As I was saying, we appreciate the opportunity to come back before the court. Your Honor, we are not just coming back because time has elapsed, but we think there have been some hardship that has gone with the passage of time. This is a crime that was basically that involved children and siblings, for that matter. But that being said, Mr. Mansfield has been held now for 8 months. He's not taking advantage of the opportunity to study. He continuously being there cannot actually organize his defense from the jail, Your Honor, as the court knows fully well. Neither can he contact any potential witnesses. Those are issues we actually argued during the bond hearing. But Your Honor, what is most important for us to impress on the court is the fact that I don't know if we made this argument sufficiently enough the last time, but we think if you inquire into his means as a minor, Your Honor, $50,000 in bond for someone who doesn't work, who has no means, true, the bond amount should reflect the crime, but it should reflect, we want to believe, the means of the defendant to post bond. And if we consider that aspect, then Mr. Mansfield should be given an opportunity to post a bond within his means. I don't know if he even if he has ever held a job, but the law is what it is. It requires the court in its discretion, I believe, to take into consideration the means of the defendant. And here we have a defendant who hasn't got the means. And there he sits with the COVID and everything going on. I will remember in your intro telling us how the process in different courtrooms is not going well with some courtrooms. We experience this every day in our work. There is a likelihood that it might take a while before he has his day in court. So we would think that the court would take this into consideration and grant him an amount that hopefully he would find a means. I don't know how, but 50,000, Your Honor, we think is likely impossible that he will ever post bond. And yet he maintains his innocence, which is a presumption that the court bears in mind. I know that for sure, because you've addressed it several times. And we would strongly urge the court to revisit the amount. True, they've indicted the case and added more crimes or more offenses, but the main one there is murder.
Right. I want to be clear. I don't view the indictment as having made the situation more serious. There were offenses added that I think flow naturally from the state's understanding of the facts. So it's not that it was a aggravated assault case and they added a rape charge. Gosh, this is even more serious than we thought. So I'm not thinking about raising the dollar amount. At a minimum, I need to allocate that dollar amount across all the counts. You're urging me to lower it because you're saying, look, proof that Mr. Mansfield can't make the bond is that he's still in there. And I don't disagree that as of today, he has been unable to post the bond. I do observe that today is also the status conference for the case. So I want to hear from you, Mr. Abitabi, if there are any discovery issues, because otherwise this case is ready to get on a trial calendar and it will be on a trial calendar in just a couple months. I don't mean to suggest that a couple months is a short time, but it is just not accurate to say Mr. Mansfield is going to languish for months and months and months. If it's trial ready, we ought to try it if it's not going to be resolved short of that, or if it's not going to go back to juvenile court, which sounds like a discussion you and Mr. Shapiro will be having. So I interrupted only to let you know that it's not that the case hasn't been moving along, and we have that other important thing to cover about the status of the case. Is there more you wanted to share with me about bond?
Not quite, but I'm pleased to hear there's a likelihood that it might be resolved in the next few months. As to discovery, let me leap to the status issue. We've not had discovery yet. And this is largely due to the fact that there's been a change of personnel on the case at the level of the state. Mr. Shapiro is about the fourth person I will be interacting with. So I would understand, but now that he's on the case and I have somebody I can talk to all the time, I'm sure we will be able to resolve the discovery issue in short order. So that won't be an issue. But if it becomes an issue, we'll use the tools we have to move the case along. But back to the bond issue, the part I really want you to consider, please, if it would please the court, is the means of the defendant. The case remains Mr. Jason Mansfield's case. And the amount of bond must be one that should be within his means. Otherwise, it's an issue. There's no point having an amount of bond that somebody who has never held a job is not even ready for the job market to have a bond amount that is, and I don't want to use this word to offend the court, but one that may sound prohibitive. So what we are praying the court to consider and is to think of his means. What does he have to pay post bond? Nothing. I know the court won't allow him to go on his own recognizance because it's a serious offense. If it were a traffic offense, we would ask that. If it were a misdemeanor, we would have asked that. But we're dealing with a serious offense, and the court took cognizance of that. But we pray and we hope that the court would have a second thought, something he can work with, and give him the opportunity to go to school, prepare for his case, and do whatever he needs to do prior to trial.
Okay.
That's our case, Your Honor. And if the court will permit, we'll step aside and let the state.
I will do that. Let me ask you one question though, and thank you for sharing that. You have no discovery, or you have only the basic discovery?
None at all.
Okay, well, that was going to be my first question for someone from the state. So let's start with discovery. What's going on?
Your Honor is very savvy with Odyssey. And if you look into the case file in Odyssey, there's been no discovery motions opting in or asking for discovery filed. That would put us on notice as to serve or give the defense counsel, right to receive discovery at this point. So as soon as that's filed, I'm sure it's waiting on deck. That's usually the ticker for the legal assistant to send it on over.
Okay, I'm going to let Mr. Shapiro, as he and Mr. Ibo Tabai have their first discussions, explain that in a little more detail, because I'm not a fan of the gamesmanship of, well, I didn't opt in, so this and that. And I suspect that there is a full desire to opt in. But why don't you clear that up with Mr. Ibo Tabai, and either he through an email can verify with you that he is opting in and will commit to getting something filed, and then you can get discovery flowing. Do either of you, I'm asking the prosecutors, have a sense of how voluminous discovery is in the case?
It's not. I'm looking at the case file, the digital case file now, which what I'll do is I'll put it in a Dropbox link to Mr. I'm not going to mispronounce his name, the defense counsel this morning.
Okay, great. So Mr. Ibo Tabai, I think you will be getting a link to get all the discovery today, but it may well be that Mr. Shapiro going forward is going to want you to commit that actually you're engaging in reciprocal discovery. And that will, I think, improve the flow of information between the two sides.
Your Honor, we would stipulate right here and right now that we would do so.
Okay, I appreciate you doing that, and that's on the record. Typically, something also gets filed in the docket, but you and Mr. Shapiro can talk about that. I don't view that as an issue. It sounds like everyone is on the same page. It just hadn't been written on the page yet, so there was some confusion there. I'll ask you, Mr. Ibo Tabai, to let Ms. Nelson, my litigation manager, know if a week passes and you don't get that discovery, because then I'll fuss at Mr. Shapiro and you'll get it. But it sounds like today or Monday, you'll get it. Second question for the state, and then anything else you want to cover about bond. Mr. Ibo Tabai raises the interesting argument that Jason Mansfield Jr. is a person of no means. He's a juvenile. And so how could you ever set a bond of more than a penny? Because juveniles don't work, they're in school, et cetera. I'm confident that's not the law, because juveniles get bond set all the time when they are transferred over to Superior Court jurisdiction. Is the proper resource inquiry the nuclear family, or how does that work?
I think because he is a juvenile, I think the proper, and I don't have any case law to back it up at the moment, but I'm sure I can find some for Your Honor. The proper resource, since he is somebody who is under the guardianship of his parents, would be his parents, as it pertains to the means for which a bond could be provided. But I bring to the court's attention that I think defense counsel made a pretty accurate statement when he said the bond amount should reflect the crime in which the defendant is charged with. And not to be a brown noser, but I think the $50,000 that Your Honor said at the previous bond hearing in February was incredibly reflective of the crimes that the defendant is charged with. And based on the factual scenario in which you heard previously, and that the defendant had lied multiple times, which really changed the trajectory of the entire case. Because initially, when he told his first lie, he wasn't arrested. He remained, a witness and somebody who had provided a statement to the officer to explain what occurred. But after the autopsy report came back, it became clear that the victim in this case, the young child who happened to be his brother, did not shoot himself in the face. That it was in fact the defendant who shot his brother. And I believe the defense counsel had provided Your Honor with some, recitation of intent. I think the intent is reflected in the charges in which the state has
Ultimately brought.
Correct.
Okay.
So I think the $50,000 that Your Honor allotted to the charges, and I understand that he was indicted on additional charges, and I think $50,000 is more than appropriate to reallocate for all of the now indicted crimes. But I think the $50,000 is more than appropriate. And I know there's several different ways for the family to attempt to make that bond through sureties and the 10% program, things of that nature. But I also think that in speaking with, reading the facts of the case and knowing them and speaking with Texas Singleton, that one place he should not go is back home with his parents. I believe this occurred because of a lack of supervision by both his mother and his father, leaving these young children in a home with an AR-15 that was readily accessible to anyone who entered the home. So based upon all that, I submit to the court there's been zero changing circumstances since the previous bond hearing, and bond should remain at $50,000.
Okay, and to address couple things you brought up. So you agree that the indictment as brought didn't make the universe of charges against Mr. Mansfield worse, such that the bond may have already thought it was too low, but it now doesn't reflect what I might have thought the situation was, because more serious charges were added. Just were charges that are ancillary, like possession of a firearm during commission of a felony that flows naturally from a murder in the second degree or involuntary manslaughter.
That's correct, Judge. I don't think the additional charges changes the realm of the reasoning behind your initial bond, which I personally think was pretty reasonable.
Okay. Second question, the bond as it stands, and I would carry over the conditions to the new bond that spreads the dollar amount across all 5 counts, would require Mr. Mansfield to live with an aunt named Ms. Caesar in College Park. That's not mom and dad, or is that the household? I'm assuming that's why there's that name and address, is that it addresses Mr. Abate's concern of not having Jason Mansfield in the house where this situation happened.
It did address the issue, Your Honor. However, that was something that I was going to need to bring to the court's attention. That home is no longer available. And so I do have information for another residence for the court to consider, which is one of the reasons why his sister Jasmine Mansfield is on. His mother is also under, just so the court will be aware, under, I believe, one of the cell phones. She cannot, she's not feeling well and cannot figure out how to change the name. So I'm not sure where, but she's here.
Okay, good. No. And Mr. Mansfield's always had family support. So his father is here, his mother is here. Jasmine Mansfield, can you unmute your phone for a moment?
Yes, I'm here.
Okay. You are
his big sister.
Big sister. Okay. You are over 18?
Yes, I'm 24.
Okay. I'm going to ask your age, just you're over 18. So you're an adult. You have your own household?
Yes, sir.
Who lives in that household besides you?
My 4-year-old daughter.
That's it? Like if I came over for lunch today, it would be you and your daughter, no one else?
Yes, sir.
Okay. And you would be willing to expand your household to include your younger brother?
Yes.
Okay. And how far away, if you were to get in a car to drive to the house where your younger brother used to live, how far away is that? Minutes?
If I'm honest, I'm not even sure. I don't know where the house is.
Okay.
Briefly, she is actually in Fort Lauderdale, Florida, and is actually transferring her job and moving here to make this possible. And she will be here on Sunday, this Sunday the 7th, but she does have an address.
Okay, and it's not the address where Jason Mansfield used to live?
No, Your Honor, she and I had a detailed conversation previously.
Your Honor, may I?
Yes, sir.
You know, I don't know why the state is going back to this issue. The court did a very thorough inquiry into this issue on the day of the bond hearing. As to where Mr. Mansfield will be placed, it's not an issue at this point.
Well, but it is an issue because if I just copied over the same bond, Mr. Mansfield would be required to live with his aunt at 4801 Crest Ridge Drive. And it sounds like that's impossible now. So we need a replacement. And it sounds like very graciously, your client's older sister, Jasmine, is willing to offer up her new Atlanta residence as a place where your client could stay.
Okay, I didn't know 408 was an issue, you know. At least it would have been shared with me before the state gets any wind of it. But that being so, we would defer to the court.
Okay. All right. So, Ms. Singleton, you can get to Ms. Nelson the address for Jasmine Mansfield's Atlanta residence.
Yes, Your Honor, it appears, based on the information that I have, that it's about 7.5 miles.
Okay.
Residence of the incident.
All right. More importantly was how Ms. Mansfield described the situation. I mean, she's going to have her space. I'm not even sure where the other place is, and we'll keep it that way. Okay. Mr. Abate, anything else from the state in connection with Jason Mansfield?
No, but we would like to respond to the state's presentation or arguments here this morning.
Okay, it's your turn. Go for it.
When the state talks of him lying, they're talking about intent. We are not here for the merits of the case. There will be a time and place for that if we ever get there. But when bond issues are considered, those are not issues that come into focus at all. Whether a crime was committed, there was an intent to commit a crime, the state has already indicted. What we're looking for is whether he satisfies the conditions for the grant of bond. And Your Honor, you examined, you went thoroughly and looked at the issues, the arguments on the 15th of February, and you found that he's entitled to bond. What we're here for right now is the issue of the amount. And as to the amount, the state have been fair and honest enough to state that they don't have any case or U.S. or state law that determines if another person can bear the burden for the accused offense. And here they're thinking that the parent should be in a position to post bond. We would want to differ. No, the person who commits the offense in the inquiry for bond is the one whose circumstance and means is considered. I'm not aware. The court might help us if there is such a statutory or case law, but we have always argued that it is the accused means which has to be inquired into. And as to inquiry, the state is also considered that Mr. Jason is a person without means. Probably this might be a constitutional issue as to whether where the defendant is a person of means, what is the appropriate amount of bond to be posted. But we would let that for some future court or some future case. But we are here to pray with the court to take into account his circumstances. A 15-year-old, no prospect of having a job, never had a job, has no inheritance, is not the beneficiary of a trust, has no skills with which he could cash in. He's basically penniless. And we would strongly urge the court to reconsider. Maybe he might talk to family members who can secure him a loan. But I'm sorry, Your Honor, but we are praying with the court that this issue of means and circumstance should be taken into account and decide the bond issue for Mr. Mansfield. It's been 8 months. I'm happy to hear this case might move along pretty soon, but for now, he maintains his innocence. He has a right to prefer his defense, look for his witnesses, prepare for his case. Is the accused right or the defendant's right, and the state has not presented any argument or any evidence or anything that shows that he cannot aspire to what we're asking before the court today. To delve into the issue of lie and intent, this is not the time and place, Your Honor.
Okay. I appreciate your points. I am for now going to maintain that dollar amount. I will enter a new bond that allocates the $50,000 across all 5 counts, and that replaces as a condition of bond the person with whom Jason Mansfield will live. It will reflect Jasmine Mansfield, and it will not be the aunt anymore. And it replaces that old address with the address that Jasmine Mansfield will have when she relocates to Atlanta. Mr. Ibo Tabai.
You know, one last thing, please, before you sign the order.
Okay.
We would like to move, Your Honor, if the court could consider the possibility of putting him under house arrest. At least he just has the chance to go to school and back home, instead of hanging out there in the jail, if that's something the court is willing to consider.
Okay, well, that was already a condition of the bond. Mr. Mansfield would be staying under the old bond with his aunt, other than school, court, or doctor's appointment. So that'll stay in there. I thought that was an appropriate condition. As I said, I'm going to maintain the dollar amount. It will be spread across all the counts. And what I'll ask you to do, Mr. Ibo Tabai, is that if you run into delays in getting this discovery, that you reach back out to Ms. Nelson, because to me, that would be a reason to revisit the question of the bond amount. In the meantime, getting you discovery is essential because this is currently set for an early October trial calendar. I'd like to maintain that date for all the reasons you've mentioned, the amount of time Mr. Mansfield has stayed at the YDC. I want to minimize any extension of that before some fact finder decides guilty, not guilty, or how this will resolve. While all that is happening, I encourage you to speak with Mr. Shapiro about whether the case is going to stay here in Superior Court or if it is a candidate for some form of resolution in juvenile court. There is a precedent for that, not just sending it back, but sending it back with a disposition. Whether that's appropriate in this case or not is not a decision for me, but for you and the district attorney's office to work through. I remain available to make sure discovery is flowing. If there are delays in that process, to either apply pressure or to say, we've now reached a point where Mr. Mansfield is sitting in a youth detention center longer than he needs to because the state isn't ready, or has made Mr. Ibo Tabai not ready because discovery wasn't provided. I get the sense Mr. Shapiro and Mr. Abate are going to fix that. And if they do, then let's all stay focused on not missing that trial date, so that if the case is not resolved by way of a plea or a transfer, we get Mr. Mansfield into court for the trial. And whatever closure is going to mean in this very sad and complicated case, we achieve that closure. Mr. Abate, anything else for the state?
No,
actually uploading now the Dropbox, so I'll have it to Mr. Both Hobby by the end of the day.
Okay, and that'll be an email from you or Mr. Shapiro?
It'll come from me, but I'll CC Mr. Shapiro.
All right. So Mr. Ebo Tabai, you were going to say something, you can say in just a moment. You should be getting an email with a link to Dropbox where all the discovery the state has in your client's case is available for you to download. Okay?
Thank you, Your Honor.
Yes, sir.
We appreciate the opportunity to come back here and address this issue with the court. We are pleased to hear things are on a pretty fast track. We appreciate that. And that being said, Your Honor, that's my time with you this morning. May I be excused?
You may in just a moment. First, thank you for those comments. I appreciate your patience with the process. It'd be great if it moved even more quickly, but at least it's moving. I think your client's father had a question. His hand is raised on the screen. Mr. Mansfield, did you have a question?
Yes, sir. I want that. They say I'm hearing you have additional charges.
So I don't want you to get concerned, and I certainly want you to speak with Mr. Ebo Tabai, who will be able to explain it in more detail. But they are all related charges. There's nothing new. Your son is charged with shooting and killing another child of yours. And a natural additional charge with that is, hey, you used a gun to commit a crime. In Georgia, if you use a gun in connection with a crime, that's another charge that gets brought. That just wasn't on the original complaint when your son went into custody. It's been added. It doesn't make the overall situation more serious. It's a related offense that the state brought, which is why I'm not increasing the bond amount. Okay?
Okay.
All right. You're welcome. Thank you, everyone, in connection with the Mansfield case. You are free to go.
Thank you, Honor. Happy Friday.
You too. Thank you, Ms. Singleton. Is that your one matter here? As long as you get to Ms. Nelson, all the contact info, the address and correct spelling of Jasmine Mansfield's name, we'll bake that into the bond. Thank you. All right. Okay, we've got Tutman and Bright, both your clients. Ms. Feely, do you have a preference as to the order in which we handle those?
Mr. Tutman has his mother here, so we could go ahead and proceed with this.
Okay. Mr. Shapiro, you're handling Tutman.
I am.
Got who we need from the state side.
I looked at the charges. Should have looked at them.
Okay, Mr. Tutman, why don't you come up to the podium, please? Just calling your case up on my screen here. All right. Let's get on the record in your case. It's State versus Michael Tutman, 19 SC 165671. This is an old case. Mr. Tutman, we are here today because Ms. Feely, who is now your lawyer from the Public Defender's Office, has asked that I reconsider your bail situation. One reason why your case has aged as much as it has is that Ms. Feely's predecessor on this case, Mr. Franklin, who was your lawyer for a while, he actually asked me to freeze your case. Don't do anything, because Mr. Franklin told me that he spoke with you and he were not comfortable going to trial during this COVID time, not necessarily for a health reason, but because we were working through what would a trial look like. The process was different. It wasn't the kind of trial Mr. Franklin was familiar with in the pre-COVID days. Ms. Feely has since asked that I remove your case from judicial hold and make it active again. But I want to just start with the observation that while many days have passed since you've gone into custody, a big chunk of those were because of what I would call a defense decision to say, don't do anything with the case. That doesn't mean you're not eligible for bond, but an argument that your case has been sitting around for a long time needs to be modified a bit with the observation that I made that I actually asked Mr. Franklin, could we put Mr. Tutman on a trial calendar? And his answer was no, because I'm not sure what a trial would be like as we emerge from COVID. Ms. Feely's in the driver's seat now on the lawyer side, and she has said, yes, we could bring Mr. Tutman's case to trial. And I am anxious to do that. But I'm going to hear from Ms. Feely, and then the gentleman seated behind you to your right, Mr. Shapiro, is the prosecutor on the case. I'll hear from him, and I'll let you know what I'm going to do. Ms. Feely?
Thank you, Your Honor. I think the court is at least somewhat familiar with this case. This involves very stigmatizing accusations. But we would ask the court to focus on the bond factors. As the court has noted, he has been in jail since November 27th of 2018. That's 1,348 days as of today. Mr. Tutman is 28 years old. He's born and raised in the metro Atlanta area. His whole family is here. He doesn't have any ties to anywhere else. His mother, as I mentioned, Mahogany, is in the back of the courtroom in support of him. He has always lived in metro Atlanta. He graduated from Paulding County High School in 2013. And he had 2 jobs at the time of his arrest. He was working at Burger King full-time, and then he was also working for a production company. So he was setting up stages for various events and concerts at the Roxy and State Farm and other venues. So he was gainfully employed at the time in 2018 of his arrest. If he was released, he would live here in the metro area in Forest Park with his brother. I believe any concerns could be addressed through bond conditions if the court had concerns about Mr. Tutman's release. But I would point out to the court that Mr. Tutman stands before Your Honor with no convictions. He does have a prior arrest, I understand, but he's not on probation or parole. He has no pending cases. He has no failures to appear. He has nothing that would statutorily dissuade Your Honor from setting bond. We would submit that he is not a danger to persons or property, not a risk to commit further felonies, as he doesn't have any history of that. He's not a risk of flight, and he's not a risk of intimidating witnesses. These accusers are relatives, but he certainly understands that he would have no contact with them if he was released.
And the relatives are also in the Atlanta area, or at least were at the time of the allegations.
Yeah, it's my understanding. Additionally, we would like to address the safety concerns at the jail. That Mr. Tutman, he is on the alternative lifestyle pod now, but I don't think he has control over whether he gets to stay there or not. I know he has been moved before to regular housing. There have been. Is
he there because of these charges, because of situations that have happened at the jail, or because that's the right place for him to be right now?
I don't want to get into too much confidential information, but he would allow me to state that it is lifestyle related.
Great.
There have been fights, there have been stabbings. The inmate workers who come up to his pod have used homophobic language and threats. He's seen people with knives. He himself has not, thankfully, been the subject of a weapon assault. And he tries to stay out of the way. But again, he doesn't have a lot of control over where he's housed. So all of that to say, Your Honor, we do believe that he is a good candidate for bond based on his history, and we would ask the court to set bond in the amount of $30,000 with any conditions the court sees fit.
Okay. Mr. Tutman, how long have you been able to be in the unit you are currently in?
Since I was first arrested. But I have been moved to like administrative lockdown, like segregation from everyone. like 3 times.
Because of something that happened?
Yeah, because they just felt like it'd be safer for me to be somewhere else.
Okay. But the only time you haven't been in the unit you're in now was for safety reasons.
Yeah.
You've never been in, I'm making up a term, but general population and put you on 7 South or 6 North or
No.
something to be mixed in with everyone else.
No, but even on the 7th floor, like administrative lockdown, it'd be fires and stabbings up there also.
I don't think there's a happy space there, but it does sound like your request has been honored throughout your stay there, with the exception of a few lockdown situations. Is that correct?
Yes, sir.
Okay. All right. Thank you for sharing that. Mr. Shapiro.
Thank you, Judge. The state is requesting that Mr. Tutman continue to be held without bond. The state's position is that Mr. Tutman continues to pose a significant threat to community safety. As Ms. Feely alluded to, and as the court is aware from the warrants in this case, this matter involves very serious allegations. Mr. Tutman's charged with over 13 counts, all of which involve sex acts committed against children. The victims at the time of the offenses were 10 and 13 years in age.
It's a total of 2 alleged victims.
That's right, Your Honor.
Just multiple allegations from each of the, it's not 13 victims.
No, that's correct, Your Honor. 2
Okay.
victims and multiple allegations related to each victim. In addition to this case, Mr. Tutman was arrested and indicted in 2016 in DeKalb County for a similar offense for child molestation and sexual battery against a 9-year-old victim. So in addition to the threat to community safety, the state believes that Mr. Tutman also poses the risk of committing additional felonies if out on bond. It's the state's understanding that at the time of these offenses, Mr. Tutman was actually out on bond in the DeKalb matter. And so the state believes that there is the risk that additional felonies will be committed. Lastly, the state believes that Mr. Tutman poses a significant threat of intimidating witnesses in this case. As was just mentioned, all of the victims, as well as the initial outcry witness in this case, are directly related to Mr. Tutman. He's familiar with where they resided at the time of the offenses, was able to gain access to the victims through his relationships with the family members and the fact that he was often over at those residences. And so it's the state's belief that Mr. Tutman poses the risk of intimidating those witnesses and the victims in this case if released on bond. And so, Your Honor, for those reasons, we're requesting that he continue to be held without bond while this case moves forward to a trial.
Couple questions. Is it your understanding that the 2 alleged victims continue to reside in the Atlanta area?
Judge, the most recent information that I have for the 2 victims is for an address in Scottsdale, Georgia. And
Where would that be in Georgia? Yeah, I can look it up. If you don't know.
I'm happy to look it up,
Okay.
Judge. I'm not real familiar with it either.
I think it's a little east of Decatur,
Okay.
like towards Clarkston.
Okay. So it could be in DeKalb County. Okay. Can you, something got delivered for me that I saw got delivered that I had been waiting on. So I'm glad it's here for another matter. And so it was right when you mentioned DeKalb. Mr. Tutman was arrested in DeKalb. And did you say indicted in DeKalb?
That's correct, Judge.
So Mr. Tutman has an open, active case in DeKalb County with similar charges.
I've requested information about what is the status of that case. However, what the state received was an indictment against Mr. Tutman in DeKalb County for the child molestation and the sexual battery charges. So unfortunately, I don't have any up-to-date information on what's the status of that matter, but I've requested it and we can provide the court with that if.
But more to the, it's not just an arrest. There was an arrest and a presentation to a grand jury, and a grand jury in DeKalb County indicted Mr. Tutman for what I'm going to call similar offenses.
That's correct.
Okay. And your understanding is that Mr. Tutman would have been on bond for that situation when this situation arose.
That's correct, Your Honor.
I don't have the indictment in front of me, the Fulton one, but I can look at it. It's not that the allegations are from 2014 and it's a 2019 indictment, and the DeKalb situation occurred after 2014, but before 2019, if that makes sense.
No, that makes sense, Your Honor. And let me just confirm one thing very quickly. That's correct, Your Honor. Mr. Tutman was arrested in November of 2018 on these charges, and so that would have been following the indictment in DeKalb County.
Okay. All right. Ms. Feely, anything you want to say in response to what I heard from the state?
Unfortunately, I don't have additional information about the DeKalb County, but I will look into it and follow up as well.
Okay. I know you are newer to Mr. Tutman's case. There actually was a lawyer in between Mr. Franklin and you working on the matter. Where do you feel the case is in terms of discovery, you being ready to go to trial on behalf of Mr. Tutman?
I have not had an opportunity to go in depth reviewing everything. It does look like I have most of what I would need. And obviously I've met with Mr. Tutman, but I would like the opportunity to speak with Mr. Shapiro about resolution short of trial also. So with me being hopefully in trial next week, that puts our timeline back a little bit, but this is definitely a priority given the amount of time he's been in jail.
Sure. And it'd be clear, Mr. Tutman, it's a priority for me again. Your case was a priority, and then I fully understood and respected and complied with Mr. Franklin's request. And you weren't the only one. He had 3 or 4 clients with whom he had discussions and then got back to me saying, please stop putting these on a trial calendar because I'm not going to try them as we're working through some of the COVID protocols. Trials now are pretty close to being back to what they were like before, and we do them all the time. In fact, Ms. Feely may do one starting next week. And so that's why I think she said, let's get Mr. Tutman back in the flow. And we have done that, and we will do that. I am for now going to leave Mr. Tutman in a no bond status, but 2 things, Ms. Feely, and this will be after you work through what's going on next week. Learn what you can about the DeKalb situation. And if it is more complex than Mr. Shapiro was able to represent, I'm not suggesting he held anything back. He said, look, I don't have that information either. But if that's been dismissed, it was null prost or something, we should have another conversation. But right now, I'm not finding that bond would be appropriate in light of on bond from DeKalb for similar charges and then new charges in Fulton County. That would be my primary concern. But the other thing I'd ask you to do is when you get a chance, put your arms around the file and see if there's something missing. And if that's something missing, the state says, oh, it's going to take a long time to get that. Another reason for us to talk about bond. Obviously, let Mr. Shapiro know you're missing something. But if he says, great, here's the Dropbox, then you've got it again. I don't think there are any pending. I know there aren't any pending substantive motions. That doesn't preclude you from doing your in-depth dive into the file. And if there's a motion to suppress a Jackson Deno, something we need to work through, let's do that. But my goal would be to get Mr. Tutman on one of our late summer, early fall trial calendars. There are not, fortunately, it's a terrible number, but fortunately, there are not many cases that are older for folks who are in custody. And so we need to get Mr. Tutman either that trial or a non-trial resolution, negotiated plea, blind plea, whatever it might be. But you and I both know that's going to happen only when there's a trial date. And so I'd like to get that trial date that's consistent with you being ready. So those are the 2 things. Learn what you can about the DeKalb situation. And then if there's just all sorts of discovery that you don't have and the state says it's going to take too long, then let's revisit bond. My preference is to get Mr. Tutman into court for his trial or other resolution of the case. Okay.
Thank you.
Mr. Shapiro, you'll work with Ms. Feely on the discovery front. She may have everything. She didn't say she didn't. She said, I need more time with the file. But if she's missing something and lets you know, you'll do what you can to get it.
Absolutely, Judge.
Mr. Tutman, do you have any questions about what we discussed?
No, sir.
Okay, we'll get you back here soon to either talk about bond more because Ms. Feely learned more, have a motions hearing if Ms. Feely looks through the file and realizes, wait a minute, you talked to the police and they didn't Mirandize you. I'm making that up. I don't know that happened at all, but there could be something in the file that prompts a motion. Or we'll get you back here because it's time to have a trial and that's what we'll do, or you've managed to work the case out. Okay, thank you. So in a moment, we're going to do Mr. Bright's bond hearing. I need to take up one matter Mr. Wade, my thought was maybe we all go into the jury room to talk if the juror is here. I saw someone coming in and out of court. Okay. Do you think she'd be comfortable if we went to the jury? That way I don't have to shoo everyone out of the courtroom. I don't think we need to get it on the record. If something needs to be on the record, we will come. Thank you so much. We will come back out here and Ms. Rivers can take something down. But that's my proposal. Does that work for you?
Yes, sir.
Excellent. All right, let's all drift towards the jury room. We're going to have a 5 to 8 minute break. If anyone on the Zoom wants to take a break, you can step away. But when we get back, we will do Mr. Bright's bond reconsideration motion. Once I have heard that, we'll press on with the rest of the status conference. I know there are a few folks who've been hanging loose for that. We'll do that as soon as we can. We already did Mr. Mansfield's. Great.
Spanish interpreter for Torres Vasquez case. I think it was. I just wonder if one of y'all might.
Number 11.
Okay.
We should get to that calendar after this last position.
Okay.
Yeah.
That sounds great. Okay.
Yeah.
Well, I'm just gonna head back to the office for a few minutes
Okay.
and be back in about 10 minutes.
Awesome. If for some reason he starts it, I'll let you know. that
Okay.
you're available.
Okay, thank you.
Thank you.
Yeah. Yeah.
all the same.
So listen, we had phone block in the courtroom. You ever said anything? No questions. You need to use the phone. Step outside. If you go, just turn them off. Turn them off. Yeah, I got mine. I understand. I like my phone. So I turn it off, put mine on off, or I turn it off on mute. Some judges will confiscate your phone and make you pay them, but you might do what now? Look at the camera. Okay.
Do you have the transport list? Do you have the transport list?
Well, they came over.
Mm-hmm.
Actually,
Conley?
Who you looking for?
Conley?
Well, I won't say he's on there. He is on there. He's on the 1 o'clock.
Perfect. Okay, great.
He's on the 1 o'clock.
Thank you.
Yeah, he's done. Yeah. Matter of fact, you got him up here. You brought him up. Guy's name is Conley. He was looking for downstairs.
Right. And I'm fine with that.
Well, I didn't think he would be on the transport list because he wasn't arrested until like the day. Okay, that's fine. That's totally fine. Thank you. What's on? Are we covering the system?
I
Okay, that's fine. It's okay. I'm just thanks.
This morning.
What was it this morning?
Travis is gonna come back.
Okay, cool. Thank you.
I figured. Always threatening to do. Because I just have to buy it too. I just have to that there. And then that was left more so confusing. But as soon as yeah, and of course, let me know if you're missing anything.
Why, Lee, are you listening to me on right? Do you know?
I don't think so.
I think the only thing that's outstanding is the GDI report.
Well, so
Why you're not really there?
let's see.
I wish I could.
I've had it too, where it just crashes. So how much? It's just a rent. Yes, it is.
Yes, that. So you let me get that.
Awesome, thank you.
Whatever that is.
How long have you been in Fulton? Okay, I've been here since May.
Yeah, a lot of us came over at the same time. What's going on? It's good?
Who do you have that's in custody still?
Yeah.
So wasn't in custody when we were here and he decided to come.
And he's here?
Oh, great.
Status.
Do I need help with moving that, make, take them down?
Yeah.
Y'all good?
We got 5, 6.
Ready to go? Y'all wanna do it?
Yeah.
I'll help you.
These can come back up.
You got the email figured right up? I mean,
I said the email.
I can stay, me and Will, me and you, to take them down.
Thanks.
Usually you don't have to restart it.
This thing closed? Was it closed?
No.
It doesn't. Okay.
They offered a lot more money. In
Yeah,
Fulton.
10 bucks. Judge Gordon, she's here.
Really?
And I was in, of course.
Mhm.
He was, I was in the courtroom,
Here?
Yes.
I think I saw his name on like the presiding list or something.
He was, the same judge.
Because I was thinking, because I was going to have a trial last week. I was like, if I show up and it's Judge Corsi, of all people.
Of all people, right? Right. I walked in this court and soon as someone came in trying to do a trial, she was making eye contact. He said, hey, come on the reset. We was back there back to talk about 20 minutes.
Nice. Yeah, it is.
Is he still over there? Or is he gone? Of course, he's still over there. Or is he done?
No, he's still here.
Oh, yeah.
He's the same judge over here. He's retired. Yeah.
Oh, okay.
We all left right within a year. We all left about a year.
I'm not sure he's lazy, but he got arrested, so.
Yeah, okay. I couldn't remember if it was your guy.
It's, yeah, it's hers. Okay, she'll- Well, don't have to worry now.
No.
You know Bowman?
Oh, yeah.
He's a investigator.
Oh, wow.
He's trying to get this situation.
With the DA's office?
Sergeant, Dr. Grant. She was.
Oh, yeah.
She's over here too.
Oh, yeah, I was in the courtroom with her for a long time.
I don't remember, I can't remember if she was, but yes, so he is.
She's got the most expressive face though, when things are going south.
She's funny.
She is hilarious.
There's and today I was like, let me just check, like, and it's awesome. And then, so yes. Right, I know, I'm so impressed. But there.
I have heard that name.
She was a special prosecutor.
And he did.
Simone Hilton's over here.
Simone is our-
Um, feel like there's some other DAs too, but then, and Rachel Gordon from my office. So Rachel Gordon did SB 440s. She's over here too. So you'll run into her. I'll tell her to look out for you because she's in all the courtrooms.
I've seen lots.
I love it. I know. I keep waiting on something to be like not as good or whatever, but it's. Were you assigned to a courtroom?
Well, I was assigned to Courtney Johnson.
That's what I thought.
They took me on transportation. So then I went from there to state and special ops.
Oh, yeah.
He's a heavy.
I was gonna say, why don't we get him? You know who we need to get over here? Sanchez.
Yeah, Sanchez ain't gonna go. Sanchez doesn't captain.
Yeah.
They have no.
The public defender's office doesn't have any either. The public defender's office is the same way.
In fact, Sanchez is man important. This over where they have
oh my gosh.
On the ground floor.
Well, I saw yesterday they had like an evacuation.
At the courthouse, yeah. I heard it was just like a car wreck or something, and but it shut the power off.
Me and Harris talking trying to get I'm talking to come down.
You know, when I first started, Sanchez and I were in recorder's court.
Really?
That was a long time ago.
They moved the guy to jail. He moved to jail for almost a year. And the chief judge down there. Damn. Get on down here.
All right, what else do I have? We have inmates coming this afternoon too. Okay.
Oh, I got order. Yeah, I'll do this.
No, I have Torres and he's at 1:30.
I don't know what's we in chairs today.
I'm older. I don't want to argue anymore. Like, whatever. Yeah, bro. I see that good.
Just stay busy. How are you?
You don't want as many emails and phone calls again. I'm the worst at returning a phone call. I'll be the first one to admit it. You know, we have a vehicular together.
We have something together. I need to get worried about it.
I think it's vehicular, right? I forget his name. I'll look.
Oh,
It's a fairly new case. That one's something we could probably do non-negotiated for sure.
oh, I think, hold on. Let's look over there.
No, just after.
Goes away, and that's I said I think it's goes away.
Is that two days ago we got?
Do we know where Miss Feely went, or are you gonna cover the bond hearing? There she is. All right. Ms. Wood's eyes get wide when I come out and Feely's not, and he's like, what? Duh. So when you all are ready, if we could bring Mr. Bright out, please. Ms. Feely, are there any other Mr. Franklin cases that are still on hold?
I have not run across any more, but if I do, I will let the court know.
Ms. Nelson probably know, there weren't many. I'd forgotten about this one, so I'm glad you came across it. There was one that I think has since worked out. Trim, I think Trim was one of them. Thank you very much. Yeah. I think Sherry Grant may have been one, and then she made her bond. She had a ginormous bond and she made it. And so that fixed that issue. Okay.
Yes, Mr. Bright.
Great. Have a great trip, Ms. Shake. Come back. Yeah, you will. Ms. Rivers, you still with us?
I'm here.
Great. This is position 3 of 3 on our bond hearing calendar, State versus Jason Bright, 21 SC 179177. Good morning, Mr. Bright.
Good morning.
Mr. Bright is charged with murder and felony murder. He's represented now by Ms. Feely from the Public Defender's Office, and we are here to consider her motion to reconsider bond for Mr. Bright. Ms. Feely, when you are ready.
Thank you, Your Honor. Mr. Bright has been in custody now coming up on 2 years. He was arrested September the 3rd of 2020. At the outset, I would like to point out that at this point, an immunity motion has not been filed, but that is forthcoming. I don't know why one has not been filed previously, but this, I don't know how much the court knows or remembers about this case, but this was an ongoing dispute between the complaining witness and Mr. Bright's girlfriend and then this person showed up with reinforcements at his residence while
At Mr. Bright's residence.
at Mr. Bright's residence where he resided with his girlfriend and her 2 children and then their 1 child together. So 3 children total were there.
So Horace Harris, the deceased, is someone you're saying with whom Mr. Bright had an ongoing dispute.
The girlfriend, he was threatening.
Oh, Mr. Harris had a dispute with Mr. Bright's girlfriend.
Right.
Okay.
And that person also had a firearm.
That person being Horace Harris. Okay.
I don't believe the police recovered that firearm, but he did still have the holster. But focusing on the bond factors, Mr. Bright is 34 years old. He's born and raised in the Atlanta area. His whole family is here, including his parents who have been in court before. He has his young daughter, who I mentioned, Lillian, who's 2.5 now, and she was 10 months old when he got arrested for this case. He is able to speak with her by phone, but obviously that is not a substitute for the active parent that he wants to be. He has always held jobs. He was employed as a loader at the UPS on Fulton Industrial, the warehouse there at the time of his arrest, but he's also worked as a contingency clerk for the Department of Labor. He's been a ramp agent for Delta. He's done assembly line packaging work at Fresh Express. He's done meat packing. He's worked retail, including at PetSmart. So, Your Honor, this is a situation where obviously an immunity motion needs to be filed and heard. But in the meantime, we are asking the court to consider a bond for Mr. Bright. Additionally, the conditions at the jail, similar to Mr. Tutman's situation, there have been 9 fights in Mr. Bright's immediate pod where he's housed. The court can probably see from where you're positioned that he has a stab wound right on his forehead as we stand here today. That's from about a month ago. He was assaulted and stabbed. Mr. Bright has no gang affiliations, which unfortunately seems to make him less or more vulnerable, less protected. And this is not theoretical. This is what has been happening, including his assault with a weapon as recently as a month ago. So we are asking the court to consider his relative lack of major history. He's not a risk to intimidate witnesses. He wants to get back out, get a job. He's very employable and be a parent to his daughter. And he has serious safety concerns about the conditions at the jail. So we are asking the court to consider a $20,000 bond, and he is willing to have an ankle monitor as well.
Okay. Is Mr. Bright someone that you'd want to have considered transferred to Cobb? I don't know if that situation is better. I know I'm trying to pull some people from Cobb back here to help with communication. So that would militate against ready communication, but I don't know if that would address some of the other concerns.
I would want to speak with him, I think privately, but I could let the court know that.
Okay, please do. All right. So, Mr. Abate, your thoughts about bond? I just noticed that in April, so it was April 5th. So what is that? 4 months ago today, I deny bond on all grounds, risk of flight, threat or danger to others, et cetera, et cetera. So I haven't, other than explaining how dire it has become at the jail and flagging that you'll be filing an immunity motion. That's not state delay or anything. Doesn't sound like anything has changed. Time has passed, but it doesn't sound like this just in with evidence that I may learn at the immunity motion hearing. And that may be a more apropos time to say, I need to think through this whole bond situation. I'll do it today at your request, but was there anything else you wanted to share before I heard from the state?
Just given his injury sustained at the jail, we wanted to bring that to the court.
Sure. Okay, got it. Mr. Body?
Thank you, Judge. I would submit to the court that based on defense counsel's argument, there has been no change in circumstances since the previous bond hearing back on April 6th of this year. I would just submit to the court. I would believe, my understanding from previous counsel is an immunity motion had been filed because the defendant's claims to officers and detectives with the Atlanta Police Department was that he wasn't present at the scene, so he couldn't have shot the victim in this case, Mr. Harris. So I understand that that's ever evolving, but that was my understanding is why an immunity motion had not been filed. I can go back over why the state requested no bond back in April, but since it's been a short period of time, I won't waste the court's time.
Okay. Well, it wouldn't waste, but I don't think it's necessary. So here are my thoughts. I'm not going to change things right now. I've offered up transportation services to a different facility. I wouldn't do it, but I could make it happen. But I won't do anything until I hear from you, Ms. Feely. That's a conversation for you and Mr. Bright to have. And we ought to have that hearing. And I think after that hearing, I'll be in circumstances will have changed because people will have talked about what happened or didn't happen. And I'll be in a much better position to say, you know what, this case is a different tenor than I thought it did based on the hearing that occurred in April of this year, when I learned preliminarily through proffers sort of what the case was about or wasn't about. So that's how I'm going to handle it for now. So it's a denial, but not a, I don't want to hear from you again on the question of bond. Let's get it tried. Again, we can talk about location as you see fit, Ms. Feely, but you sound pretty certain you'll be filing that immunity motion, and it would then be at the close of those proceedings that you may say not want to bring it back up, but you may well based on what comes out. Does that make sense?
Yes, Your Honor. May I speak with him before he's taken back?
Sure. No, you can go back and talk with him. I'd like to move on with the status calendar, not your cases, so we can move some of those along. But you can let me know how it goes after you two speak. Okay. Before you go, Mr. Bright, you understood what I said?
I understood, but from last time we met, you was telling me that you was going to consider, the bond, but I mean stipulations. I don't know, but I just, I just feel like it should be more to the table. Like I could present more to the table, like why I feel like I deserve a bond.
Okay. Well, it's a delicate dance that your lawyer needs to work through, because you may want to really say something on the record, and it's on the record and the prosecutors hear it. And you've already heard Mr. Abadi say, hey, you know what? This immunity hearing is going to be interesting because Mr. Bright told the police I wasn't there. And now your lawyer is saying indirectly, it's not your words, it's hers. You can't be held to it. Yeah, he was there and he did it and it was self-defense. Well, those are different stories. And if I'm a juror, I'm thinking, I just not gonna believe, one thought could be, I'm just not gonna believe anything Bright says, because first he's not there, then he's there, and this and that. So I think your lawyer is being very discreet at this time about what she wants to share. And it sounds like I'll learn a lot more. And to use your phrase, a whole lot more will be out on the table when we do this immunity hearing, because then people will be under oath saying, no, here's what happened. I saw this, I heard this. And that's why I said, let's talk about bond after that, because then I'll have a better flavor for what really went down.
Right.
Okay. And that'll happen soon.
Okay, no problem.
All right. All right, let's keep pressing on. Our status conference. Let me see how we're doing on the phone. Do we have anyone who is in a position to talk about Darrell Lowe? I don't see Ms. Love. That was continued. We continued the Darrell Lowe one? Oh, because of Mr. Cladis. Okay, great. Again, I should have read those. All right, continue. All right, how about John Fant?
He's mine, Judge.
Great. Is Mr. Fant online? Is he in court?
I think he is on Zoom. I think.
Mr. Fant, you still with us? I know it's an hour and a half after we were supposed to do this calendar, but busy times.
I thought it was under an iPhone, Judge, but I can text him.
Okay. Yeah, just looking at the charges, it would be great if he could just plug in. I'm assuming this is, he's got two cases.
Yes, Judge.
Okay, he definitely needs to plug in.
Yes.
Why don't you do that? Let's, how about Reginald Watson?
He's present.
Mr. Watson is here. Why don't you come sit with Ms. Wood, please?
He's right here. How you doing? Okay.
All right. This is position 4, Mr. Watson's case. He's charged with aggravated assault. Ms. Wood, do you believe you've got all the discovery in this case?
I believe I have everything now. And
Now, as in like 10 minutes ago, you got it, or?
no, Judge, I had made the state aware a few weeks ago that I was missing what I thought should be some body cams, and Ms. Charles got those to me. We have been talking, oh, wait,
She's here. She's just back row.
We've been talking about the case. We're not ready to resolve it yet, but I believe this is something we'll be able to resolve before she gets moved out of this courtroom.
Okay, but it sounds like we could move it to a trial calendar. It may not need a trial, but trial soon is doable from a defense perspective.
Correct, Judge.
Ms. Charles, any reason we shouldn't put Mr. Watson's case on an upcoming trial calendar?
You are.
All right. Anything else you want to add about the case?
Yeah, we're not, as Ms. Wood said, we're trying to work through it before I leave.
Great. Mr. Watson, do you have any questions?
Nope.
All right. I appreciate you being here. I just want to make sure you heard us talking about your case, and it sounds like it may be work outable. If it's not, we'll get you in here with the jury and see what they have to say about it. Your next court appearance, it sounds like, will either be we've resolved it and that gets put on the record, whether it's a plea or a diversion or who knows what, or it'll be let's pick that jury. Okay.
All right.
You still live at the same place?
Yes, sir.
Sounds good. You are free to go.
Today and give you an update.
Okay.
You're free to go.
Yeah, okay.
Yeah, one Mr. Abadi,
I believe that completes my business until 1:30 tonight. Come back then.
please do.
Thank you.
You bet. Kiera Christian. She was here. I saw Mr. Lewis here.
Good morning, Judge. We actually transferred to Zoom.
Okay. Where's your client?
She should be logged on also, Judge.
I'm on here.
There she is. Excellent. I'm sorry we didn't use your time wisely this morning, Mr. Lewis. We had other stuff going on. So Ms. Christian is charged with carjacking. Huh. Okay. Do you have all the discovery you think is out there, Mr. Lewis?
I believe that I have all the discovery, Judge, and having a conversation with my client, it appears that there was an interview that was done by phone, It references in the discovery, but I'm not sure if there's a recorded version. Other than that, I have everything that I need.
Okay. Ms. Charles, anything about a phone in, this would have been law enforcement talking to your client, Mr. Lewis?
Correct, Judge.
Okay. Ms. Charles is given a confused look.
I don't see that specific interview in the videos that I do have, so I'll make a note to follow up with the officer and get that to Mr. Lewis as soon as I have it in my possession.
Okay. Mr. Lewis, any sense of whether it was, I guess if it was on the phone, it wasn't a custodial interview. So you're certainly entitled to it, but it doesn't sound like it would be a suppressible event because your client was wherever she wanted to be while she was on the phone with this officer.
Correct, Judge.
Okay. Well, Ms. Charles has said she will see if there is a recording, and if so, get that to you. Any reason we can't put Ms. Christian's case on an upcoming trial calendar?
Yes, sir. We'd ask her to be moved to the trial calendar, Judge.
Great. Ms. Charles, does that work for you?
Yes, Your Honor, that will.
Ms. Christian, do you have any questions about anything we talked about?
No, sir.
Okay. And are you still at the same address you've been at for a while?
Yes.
You got a notice to be here today?
Yes.
Great. Okay. Well, that's it. I appreciate you all hanging on. You're free to go.
Thank you,
sir.
Creole Brazil. There he is. Your lawyer is.
Here I am, Judge.
There he is. Hey, Mr. Booker, how are you?
I am blessed. How about yourself, Judge?
I'm doing all right. Are you in a vehicle? You look like you're in a vehicle. What kind of car is that? The ceiling is funky looking.
Yeah, it's a Tesla Model Y. It has a glass ceiling.
My gosh, Mr. Brazil, how much do you pay this guy? Mr. Brazil says too much. Why is my case not yet resolved? Okay. So Mr. Brazil has a co-defendant. Is the co-defendant on this calendar, or what's the status of the co-defendant? Not amenable to justice. 344. Let's see what it says. It's got Mr. Cladis. Okay. All right. Well, let's talk about Mr. Brazil. Mr. Brazil, you are charged with armed robbery. You've got a bond and you have a co-defendant. Your co-defendant isn't here today because his lawyer had a conflict. Mr. Booker, do you have the discovery in this case?
I do not, Judge.
You have no discovery?
Not that I'm aware of.
So on March 30th, the district attorney's office sent to Robert Booker Esquire on West Park Street, Suite 103 in Lawrenceville, the indictment, police report, an arrest report, warrant, citations. I don't know that that's everything in the case, but you should have something.
Well, my office is on Pike Street. I'm not sure. Maybe that's why I didn't get it. I'll go. I'm headed to the office now to confirm that.
Okay. Yeah.
I did the prelim on this case, Judge. The alleged victim showed up and said that my client had nothing to do with the armed robbery. The court granted him a bond. I think it's a case the state obviously needs to look at. I do have the officer's body cam from the entire event. It's not a case that I'm gonna need much from the state. If they want to try this case after the prelim, I'm fine. I'll be ready whenever they're ready.
Okay. I'm going to ask Ms. Charles to double check her file. The discovery certificate says that it was mailed to you and it says e-file. I don't know what e-file. E-file to me says that you filed it into the docket. But that would mean there's no video discovery. If it was e-fileable, it's just paper.
That's
yeah, the video discovery I got directly from the police department through a subpoena. They provided it.
Okay.
No, I understand you got that on your own. So my direction to Ms. Charles is going to be to look into her file to see what's there and then to connect with you, Mr. Booker, to make sure you've got it. And if you don't, she'll get it to you. And we will take it from there. Mr. Booker, any reason to think that there is discovery out there that would trigger a motion to suppress? Or just because of the work you did at the prelim and your understanding of the case, you know if your client gave a statement or not?
He did. He gave a statement when he was there with law enforcement, but we're not concerned about that statement, Judge, based on what I've seen in the case.
Okay.
The accused came forward. If they got me whatever paper discovery this afternoon, I'll be ready for trial on Monday. So whenever if the court wants to go ahead and move it over to a trial calendar, I'm fine with that.
All right, well, it won't be trial on Monday, but that's where the case will go, is to a trial calendar. When you figure out what's going on with Mr. McBurney, the co-defendant, so that Mr. Brazil and Mr. McBurney are moving in lockstep as best we can. But I want.
They're on the trial calendar together.
Oh, good. Okay, great. All right. So that's what we'll do. Mr. Brazil, we'll move your case to a trial calendar. That doesn't mean you're going to have a trial. You've got a good lawyer arguing on your behalf, and it may be that your case resolves in some other way. Do you still live at same address? You moved recently?
I still stay at the same address.
Okay. Did you get something in the mail telling you to be here today?
Yes.
Good. All right. If you move, you got to let Mr. Booker know. Ms. Charles, anything you want to add about Mr. Brazil's case?
No, Your Honor, I'll be going with Mr. Booker shortly.
Okay, so Mr. Booker, look for a communication from Ms. Charles just to make sure you've got all the discovery.
I will, Judge. Thank you.
All right, you two are free to go.
All right, have a good weekend.
You too.
Bye.
Position 7 is Annette Saldana. Did I sign? That's been dismissed. All right, is Ms. Saldana here?
I had emailed Ms. Nelson to ask if she could be excused. She's my client from Miami, so.
Okay, it's fine if she's not here. I know I signed a few things yesterday when I got back from training. All right, so that's a null pros. We did Ortiz already. We did Mansfield already. That gets us to Sam Greer, who should be back there. Can we bring Mr. Greer out, please? Then we have one with Mr. Lee, and we're supposed to have an interpreter. Who's right there? Oh my gosh, how are you? I haven't seen you in a long time.
Yes, Your Honor, since before the pandemic.
Yeah, is all well?
Yes.
Good.
Fred Hunt.
Mr. Hunt is back.
Whoever you're asking person is sexist. Okay. Just jump. You can't see. I'm writing for these calendars. You need to check that ADA much closer. Because I'm like, luckily Adam was here, but that was supposed to be my case.
Hey, Mr. Greer, you can come on up to the podium, please. This could be interesting. Is this Mr. Cladis's case, or does Mr. Johns Harris still have it?
Judge, I believe it's Mr. Cladis's. He entered an appearance on July 12th.
Great. So we can't do this today because we have no Mr. Cladis, but I'm not going to waste your time totally, Mr. Greer. It's good you came over. You have an attorney assigned to your case who's focused just on this courtroom, a couple courtrooms, but mostly on fewer courtrooms than the gentleman who used to have your case, which is a good development. He'll be able to spend more time with you in the case. Today, all we were going to do is to make sure that that lawyer had all the discovery. And if there's any reason why we couldn't move this case towards trial, let me see. He sent a bunch of emails. Here's the Sam Greer. It was an evidence.com discovery submission. Mr. Cladis can't get his hands on it, but he says the DA, assume that's you, Mr. Shapiro, is working on getting it to him. And Mr. Cladis wants to have a bond motion on your behalf. He needs to be here to argue that. So Mr. Cladis, he's just gone today. When he's back, we'll bring you back, Mr. Greer, to talk about bond. And hopefully by then, Mr. Shapiro, if there was an evidence.com link, that tells me that discovery is in a discrete location electronically, and you can represent that That's the wrong way to put it because it wasn't Cladis's case before. You can get it to Mr. Cladis.
And that was resent yesterday, Judge.
Excellent. All right. So he's got his discovery and then he just needs to get back here so we can do your bond motion. Okay. Any questions? All right. Good seeing you, Mr. Greer. So do we have Mr. Perez Vasquez?
Good morning, still morning, Your Honor. This is Eli Bennett appearing on behalf of Perez Vasquez. She is present here on Zoom where it says Jerome D. Lee Esquire. That's my client there.
Okay. It is still morning by lots of minutes. I guess we need to see Ms. Perez Vasquez. There she is. Mr. Bennett, it on my calendar says we need an interpreter. Is that correct?
It is, Your Honor. I could provide Ms. Perez Vasquez's cell phone number so the interpreter could call and translate that way if that's the easiest way to do it, or just contemporaneously from the podium up to the court.
Option 2 is poor because that would dominate the Zoom connection and our court reporter is on Zoom. I'm not going to need to get any input from Ms. Perez Vasquez during this status conference other than for her to confirm she understood what we talked about. So maybe plan A, but let me ask Mr. Hunt. Would you be, I don't know if that's a format you've ever done before. This is lower pressure interpretation because I'm not going to need to get testimony from Ms. Perez Vasquez. And you're basically going to be summarizing the logistics that we work through. Are you comfortable giving her a call?
Yes, Your Honor, and I'll interpret simultaneously everything that's said.
Great. Okay, we'll do that. What phone number should Mr. Hunt call, Mr. Bennett?
Yes, sir. 678-500-4899.
All right. And that's a number that Ms. Perez Vasquez will pick up directly, or someone saying Jerome Lee and Associates will answer?
It's Ms. Perez Vasquez's personal cell phone number.
Great.
I have Ms.
Great.
Perez
Fant's on.
Vasquez on the line.
Okay, great. Mr. Bennett, tell me what's going on with discovery.
Yes, sir. We have received partial discovery from the state as of last night, written discovery only. I do expect to receive the forensic interview, whatever body cam video footage may be available, and the interview of my client, which I don't believe was a custodial interview, but those items are outstanding from the state, although there have been 2 productions. So I have the forensic from a previous production that was made by Ms. Patel. So we may be able to, short version is, Judge, we're working towards getting discovery resolved, and we should be able to get everything shortly and go on the next trial calendar. I don't see any problem with that at all.
Based on what you told me you're missing, it doesn't sound like any motions to suppress would flow from that. Everything you described you're entitled to, we need to get to you, but we would still be able to move towards trial and not need to pause for a evidentiary hearing. You agree?
I agree. I think it's unlikely there's going to be any suppression issues with this case.
Okay. Should they arise, let me know. But otherwise, it sounds like we could move the case to a trial calendar, assuming you can get the discovery you're entitled to. Mr. Shapiro, your case?
Yes, Judge.
Is Mr. Bennett telling you things that surprise you about discovery?
Judge, I resent, I attempted yesterday just to compile everything in that evidence.com link and to resend that to Mr. Bennett. So I'm happy to take another look and see what the issue is as far as him not receiving the forensic interview videos, but we'll clear up whatever the miscommunication was. And I did receive an email from Mr. Bennett this morning just saying that there appear to be some duplicates. So we'll get that sorted out.
Okay. Mr. Bennett, I'm not familiar with Mr. Lee's overall practice. Are you going to be the primary attorney on the case, or is that Mr. Lee? Who do we need to be keeping track of?
It's going to be me, Your Honor.
Great. Have you filed an entry of appearance?
No, Your Honor. I've been traveling under Mr. Lee's entry. If the court requires me to, I'd be happy to.
I don't require it if there will never be an issue whereby you say, I didn't know that went to Jerome Lee.
Fair enough. The email address that's on the entry is department wide. So as long as the whatever communication from Your Honor goes to criminal@htlweb.com, I'll get it. Mr. Lee will get it, and our two legal assistants will get it as well. So yeah, that you won't hear any complaints from me about that, Your Honor.
Okay. That works. Mr. Shapiro, anything else in Ms. Perez Vasquez's case?
Nothing on behalf of the state, Judge.
Okay, we'll move it to an upcoming trial calendar and take it from there. Is this a case, Mr. Shapiro, that you think could resolve shorter trial, or based on your read of the file or communications with defense counsel, it's a trial?
I communicated and offered to Mr. Bennett yesterday. Don't mean to speak for him. It was my understanding that he would need time to discuss that with his client.
Of course. Mr. Bennett, based on the state's offer, it may be the first, it may have evolved. Is this a case you see working out, or there's such a wide gulf between what you think is reasonable and this offer that it's not likely?
Well, Your Honor, I still haven't had the chance to discuss the offer with my client. I do think that we'll be some back and forth about possibly negotiating this case short of trial. So I'm hopeful that we can negotiate a plea agreement in this case for sure.
Okay, great. No pressure. I was just curious. Mr. Hunt, can you ask Ms. Perez Vasquez if she has any questions?
I just want to say that I'm not sure why I'm being charged if the victim says that it wasn't true.
Okay, that's not a question, but I appreciate her sharing that.
Okay, no other comment. Thank you, Your Honor.
All right. All right, Mr. Bennett, appreciate you hanging in there.
Yes, sir.
And you are free to go, as is your client.
Thank you, sir.
And Judge, that's all I have until 1:30. May I be excused?
Yes, sir.
Thank you.
James Barron.
He's on the Zoom call, Judge.
There he is. Hey, Mr. Barron. Hey, you're in that same like wooded basement as you were last time. So Ms. Wood, your case, there's not a defense attorney listed. All right.
Yes, I filed in recently, Judge.
Okay. Discovery.
I believe I have everything. I believe this is Mr. Whitenauer's case now.
Okay. It says Ms. Charles on the calendar. Do you want Mr. Shapiro to stay here, or who's going to talk about it from the state?
I can go ahead and talk about it from the state.
All right. Mr. Shapiro is going to turn back around and leave.
It's fine.
Sure.
So Ms. Wood thinks she's got all the discovery.
Looking at all the CAC, everything we sent yesterday by ADA Whitenauer.
Okay.
Can't be, if there's anything else you missed, just let us know. We'll get that to you.
Okay.
And was it sent just yesterday because he didn't know where to send it, or why would it have been sent just other than, I have a status calendar tomorrow, I better do my job?
Judge, I believe you could just give me one moment. I know Miss Nelson and I had talked about this case. This case came on a calendar when I was not here. Miss Primovic covered for me. Mr. Barron qualified in court.
Oh, right.
So unfortunately, there was a bit of a delay in me getting an entry on the case.
Okay.
Let's see, I notified Mr. Whitenauer on the 14th of July that I didn't have discovery, and then he was out.
Yes. Okay. So you should have gotten it sooner, but I sort of understand why that happened.
Yes.
Let me pause for 1 second. Mr. Hunt, do you have I don't mean to keep you here longer than you need to be. Was that it?
Ms. Nelson.
Sure. Great. Do you have a sense from the very few minutes you've had discovery, whether one, they're going to be motions, or two, I can tell I don't have everything because the police report says confession, 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 and there's nothing in there?
I don't expect motions, Judge. This is a 2018 case. Mr. Whitenauer and I are working towards a non-trial resolution, which is not there quite yet.
Yep.
Mr. Barron is aware of that. He's been very engaged in working this case out. And so I'm hopeful that we can get back before the court in the next couple of weeks.
Okay, good. So moving it to a near-term trial calendar doesn't compromise your ability to get ready.
No, Your Honor. And if we could do that, and then I'll just let Ms. Nelson know once we have something worked out.
Yeah, as always, we're always happy to make time for workouts. Ms. Charles, anything else you want to commit Mr. Whitenauer to? That's it. All right, Mr. Barron, any questions?
No, Your Honor.
All right, well, you are free to go. Thanks for hanging in there.
Bye, Mr. Barron.
Zolly Ford.
He's present, Judge.
Hey, Mr. Ford, come on up, please. Did I pronounce your first name correctly? Great. Mr. Ford, you are charged with aggravated assault and aggravated battery. You're out on bond. Ms. Wood, do you have discovery in the case?
I do, Judge. I believe I have everything in this case. There's a number of videos that Ms. Charles has shared. I'm working my way through those. I haven't seen any issues for motions as of now.
Would they be body cam videos or surveillance videos?
Body cam.
Okay, officers responding to a scene.
Yes.
Okay, but lots of officers.
Yes.
Okay, so lots of videos. All right. So I guess same question. Any reason we can't put the case on a soon to appear trial calendar?
No, Judge, that's perfectly fine. And again, same situation with Mr. Ford's case. Ms. Charles and I are working to get something for this one before it actually reaches trial. And so if we could just put it on the calendar, and then I'll just let Ms. Nelson know.
Okay. Mr. Ford, do you follow all that?
Yes, sir.
Your lawyer's trying to work something out. If not, we'll get you a trial date soon and the jury can work it out. You still living where you were living when you got notice to be here? Great. Okay. I don't know what the conditions of your bond are. I suspect they say stay away from whoever the alleged victim is. Is that a problem? I don't know if it's a relative or a stranger or whoever it is. You staying away from that person is not an issue?
Not at all.
Great. Okay. Keep it not an issue. And we'll see you either because the case is worked out or because we're picking a jury. All right. Thanks.
You're free to go.
Thank you.
I'll be in touch with you, okay?
Sure.
And Judge, while I'm standing here, I just want to let you know, position 2 and 3, Mr. Fant, the reason that he was not on is because I mistakenly sent him the 1:30 p.m. calendar time. So it's completely my fault that he was
All
not
right.
present.
Let's do Mr. Fant since you brought his name up. You can just stand right there. Mr. Fant, can you hear us?
Yes, sir.
There he is. Woo. All right, nice hearing. Okay. Mr. Fant is positions 2 and 3, a criminal damage case, and then a aggravated assault with a gun case. Ms. Wood, do you have both those cases? Do you have discovery in both cases?
Yes, Judge.
Any impediments to you being ready for trial?
No, Your Honor. Same announcement with this one as the previous 2. We're working on getting this one taken care of before Ms. Charles leaves.
I'm envisioning a big old going away party where there are cupcakes and mountains of pleas.
Yes.
Excellent.
Or in all process.
Or whatever it is. Mountains of this case is closed.
Yes, Judge, that is our goal as well. Mr. Fant, you and I will just get together. I think he's been under the weather this week. And so once you're feeling better, I just need you to come into the office and we'll go through everything, okay?
Yes, ma'am.
All right. Ms. Charles, any reason we shouldn't put Mr. Fant's 2 cases on a trial calendar? All right. Mr. Fant, do you have any questions?
No, sir.
You do not need to dial back in at 1:30. This takes care of all your business, okay?
Yes, sir. Thank you.
Sorry, Mr. Fant.
Are you still living at the place you were living at when you got your bond?
Yes, sir.
Okay, good. If you move, let your lawyer know.
Yes, sir.
Thank you.
All right. Thank you, Ms. Linwood.
Have a good one.
Yes, sir.
All right, Aaliyah Howard. She has come on up. And Brian Howard is making himself visible. Fantastic. Sorry to keep you guys waiting.
Not a problem.
All right. Mr. Howard, you've heard the routine. Do you have discovery in this case? Any shortcomings?
I always hate to say this, but I don't think I have the discovery I don't see it in my file, and I looked online, I didn't see a certificate. And I definitely need that, obviously, so.
You do indeed. Let's see what the docket is telling me. I don't have anything in there that any discovery was served after plea and arraignment. Scheduling order was entered on May 16th, a couple days after plea and arraignment, when I would have first met Ms. Howard. And discovery was due by the end of May, motions deadline middle of June. And here we are with a status conference. So Ms. Charles, tell me your understanding of what's going on with, I'm looking at these charges. It doesn't seem like there'll be a lot of discovery. I mean, there could be a bunch of body cams or something, but this isn't a crime lab kind of case.
First, apologize. This was cracks. I will definitely get it out today.
Okay. And get it out means you'd be sending Mr. Howard a link, or you'll be sending him a box that has this.
With the video that we have and the audio, as well as uploading all the report words and put in MS.com, all of that in one link.
Okay. Are you aware of whether Ms. Howard gave what could be construed as a custodial statement in this case?
No, Your Honor.
No, you're not aware, or you don't think it happened?
There, this, 3 videos, and no, there was no custodial videos.
Okay. And I'm only asking Ms. Howard because your lawyer, Mr. Howard, needs a chance to digest what he's about to get, spend time with you talking about it. And he'll be looking at it through at least 2 lenses. One is, all right, what kind of defense do we have? She wasn't there, someone else did it, something like that. But also, oh, this is not great for us. Oh, but we can suppress that. That officer was asking you all sorts of questions. You had handcuffs on, you weren't Mirandized. Mr. Howard jumps into action and files a motion about that. Doesn't sound like that's how this one played out, but he needs a chance to look through it. Mr. Howard, assuming you get a link sent to you today that allows you to download all the discovery in this case, it does not sound like it's particularly voluminous discovery. Pardon me?
It's 9 pieces of evidence.
9 pieces of evidence, but some will be video, so it's not that it takes 1 second to look at it, but they're not hour-long videos. Assuming you get all that today, do you think that you'd be able to let Ms. Nelson, my litigation manager, know in the next week or so if you had any evidentiary motions?
Yeah, I don't think that'd be a problem. Absolutely.
Good. Because if you don't have any, then it does mean we can move Ms. Howard's case to a trial calendar. Doesn't mean it'll be a trial. That's just the next marker and really the forcing mechanism that will get Mr. Howard talking initially with Ms. Charles. Ms. Charles, regrettably, is leaving this division to go do bigger and better things. There'll be a new prosecutor. So you may, Mr. Howard, want to strike while the iron's hot. If you've been listening in, it sounds like she's trying to resolve a lot of her cases before she goes, just to make life easier for the incoming prosecutor. And this may be one of them. I don't know anything about the facts, but hopefully, Mr. Howard, you can connect with Ms. Charles before, I think she's with us through the end of the month. Is that about right? Yes, yeah, through the end of the month. So hopefully you two can talk to see if there's a non-trial resolution. If not, trial's a trial, and whatever prosecutor's here needs to be ready for it.
She's always been reasonable, Judge, so I'm hoping we can resolve it.
All right, well, good. Ms. Howard, do you have any questions about any things we talked about?
No, sir.
Okay, I'm sorry we kept you here all morning. We're catching up, so we have a congested calendar today. Do you still live at the address that you were at when you got your bond? Okay, if you need to move, let Mr. Howard know so that he can track you down for your next court appearance.
Okay.
All right?
Thank you.
All right, Mr. Howard, look for that discovery. If you don't get it, let Ms. Nelson know so we can fuss at Ms. Charles.
I'll do that.
Before
Thank
he
you.
goes, can I just confirm?
Don't go
his
yet.
Email is.
Okay, yeah.
Brian,
Do you want me to just, can I
No.
put it in? It's Brian, BRYAN, at Howard spelled out,
Yes,
and spelled out,
yes.
ARCA.
.com.
Yes, ARCA's
Okay.
ARCA.
Perfect. Look for my link in about 5 minutes.
Okay, thank you.
Boom. All right, you have a busy afternoon. Thank you, Mr. Howard. You are free to go, and Ms. Howard, you too. Thank you
Have a
for
good
being here.
weekend, Judge.
So we're either going to have a very crowded trial calendar, or there's going to be that big farewell to Ms. Charles cupcake and disposition party. 2 cases left. Our most patient defendants. One is is it Paul? It's Cody. Polio or Polio?
Yes, sir. Polio.
Polio. And Ms. Bando was on.
Here, Judge.
She's still here. Thank you, ma'am, for your patience. Do you have discovery in this case? Let me pause for a second. Is this the case where the victim and the defendant are in the same indictment?
Mm-hmm. Yeah, they're cross defendants, Judge. Yeah.
This is crazy. All right, done editorializing. I'm glad they're not in the same room. Ms. Bando, do you have all the discovery in Mr. Polio's part of the case?
No, Your Honor. I'm still missing the gun residue test results.
Okay, but that's it.
Yeah, I received the videos on Wednesday.
All right, so this just in, but you think you've got everything other than what we need to get out of the GBI?
Yes, Your Honor.
Okay. Ms. Charles, have those been completed, or are you also waiting on them?
Also waiting, Your Honor, and I'll give Ms. Bando an email once I have an update for her as far as that goes.
Okay.
And one of the issues that we're having in this particular case, the CID officer is no longer with APD.
What does CID mean?
Crime scene investigator is no longer with the officer. When we did the open records request, we were told we got all of the investigative files. The lead detective is working to see if that initial reports were in a separate area because it didn't make it to evidence.com, and as well as the GBI results. So we're sort of.
So there may be more discovery to get to both Ms. Feely on behalf of Mr. Stewart.
Correct.
And Ms. Bando on behalf of Mr. Polio.
On the crime scene investigative piece.
Okay. All right. And then the GBI piece, you can only get it when they're done with it. Do you know if it's done or not, or you know it's not done?
Last time was pending, so we did an expedite request, so we'll just get that as soon as we have it.
Do you have a sense of the time frame to get from APD the other paperwork?
The officer I'm working with, he just says to me as soon as he can, so I'm just working with him. I'm working his timeline, so I'll keep pressing, and as soon as I have it, I'll turn it over.
Okay, but do you get the sense that we're talking about days or weeks?
Days,
Okay.
maybe a week or so at the most, but days. I'll keep
Okay.
pressing him.
Ms. Bando, do you think from the evidence you do have, and you may not have had a chance to go through the videos yet, that you've got, other than the gunshot residue results, 99%, you've got a pretty good feel what this case is about, or are the missing pieces significant enough that you're still scratching your head about what went on in this situation? Setting aside the fact that the defendant and the alleged victim are in the same indictment.
No, Your Honor. I was able to watch one of the videos. It was about 3 hours long. So I watched it. I wanted to at least have a grasp of things for today. But there's several other ones from the other responding officers. So I have a pretty good grasp of it, of what's going on.
Okay. Do you think that there are going to be any motions? You haven't filed any motions yet. Do you think there are going to be any as you further review things, or is it okay to view this as our next step is a trial or some non-trial resolution in the case?
There may be one. I'm still working through the videos, but I know my client was detained and talking, so I foresee possibly a motion.
Okay, got it. So Miss Sanders, we have plea and arraignment today. She'll be new to the case. I just noticed there's a third defendant. I don't know if she's also a victim or what, but she's on for plea and arraignment this afternoon. So we'll learn about her. Okay. All right. So Ms. Bando, the next step would be to put this on a trial calendar. I may put it a little further out because your client and Ms. Feely's client are both on bond. That will build in time for us, time for you to get the rest of the discovery and decide whether you want to file a motion. And then we could hear that motion. So if we had this on a November trial calendar, is that building enough? I think right now it's slated for an October trial calendar, and that may be enough time. I don't want to rush anyone, but I don't want this to get older than it needs to, especially if there's a non-trial resolution in the offing.
I think November would be suitable.
Okay. All right. Mr. Polio, do you have any questions about what we've been talking about?
No, Your Honor.
All right. I'm gonna have you both stay on the phone just because I now that I realize why Mr. Stewart is on and he's been on, and Ms. Feely who's sitting here. Ms. Feely, how are you doing with discovery?
So I think I do have everything. I haven't watched videos, but on behalf of Mr. Stewart, he is the complaining witness in this case. And so I'm researching now whether he was the victim of multiple aggravated assaults with Ms. Sanders and Mr. Polio. And he's only charged with finally getting a hold of his sister's firearm that's legally owned. So he has a legal right to defend himself even with his convicted felon status. And so I'm researching now whether that would also apply to the brief period of time that he did in fact have the firearm. So I'm hoping that we will have a resolution before too long based on that information to Mr. Charles.
So your focus is less discovery right now than legal research and then working with Ms. Charles. It might simplify the procedural posture of the case if Mr. Stewart, obviously they can't go to trial together. They'd have to sever it. Okay. So you're working on that. We'll meet Ms. Stewart today. I may have met her before. I think her lawyer rolled off the case is the issue. So
Sanders, my guy's colleague is Stewart.
I'm sorry if I said Stewart. I meant Ms. Sanders. She's coming in this afternoon. I hope she can get Mr. Cladis as a lawyer because if it needs to be C3, that's going to go. All right, Mr. Stewart, Ms. Feely's doing some legal research on your behalf. Do you have any questions about where we are with the case?
No, sir.
Okay. Do you still live where you were living when you got your bond?
Yes, sir.
All right. Well, if you move, let Ms. Feely know. Otherwise, I think Mr. Polio, Mr. Stewart, you can both go. Ms. Bando, you're free to go. We'll set this down for trial in November. And it may be that one or more of the named defendants resolve their matters well before then.
All right. Thank you, Judge. Have a great weekend.
Thank you. All right. I think that covers everything for this morning. We are back on this afternoon. I noticed pretrial is with us. Do we have any potential pleas in the afternoon? Because pretrial doesn't need to join us if there aren't going to be any pleas. And we may not need to bug Ms. Tucson either.
I don't think I have any, Judge.
No? Okay. Ms. Tucson and pretrial, you guys are welcome to plug back in at 1:30, but it doesn't sound like, much to my dismay, that I get a welcome back, Judge. We resolved some cases. I guess there was the null process. I've got Mr. Torres down as a plea. That's what it says. Not a plea. Is he able to take a plea?
Right, exactly. I think
trying to see if he was able to. I don't know.
And Ms. Patterson is going to be on to address what we're working on for him, but I do not anticipate a plea.
Okay. False alarm. Okay, let me just look at the calendar. So like our obstruction case, that's not going to be a plea. Jason Sherman too. Okay. All right. So I think we'll be good to go. It's Friday afternoon. I don't want to make you guys sit around for long calendars. As long as Ms. Tucson, we know how to reach you if we need to get you on an emergency basis.
No problem. You guys just call my cell.
Okay. And I'm sorry, because I'm new to benefiting from pretrial. I don't know if Bostic is male or female, so I don't want to say Ms. Bostic when it's Mr. Bostic. Female. Ms. Bostic, is there a number we could call if we needed you to parachute in if we ended up magically having a, hey, I had lunch, now I want to plead?
Yes, Judge, do you want me to send it to you or to someone else?
You send it to me. That'll be great. Just send it to me through the little chat. I'll write it down and we'll call you if we need your good information this afternoon.
Yes, Judge.
Just got it. Whoa, where's that area code from?
That's Florida.
Okay. Are you in Florida right now?
No, I'm not.
Okay. All right.
I just never changed my number.
All right. Thank you, Ms. Bostic. Have a good weekend if we don't call you.
Okay, you too, Judge.
So it's same Zoom link? All right. So Ms. Rivers, Ms. Patterson, we will see you all at 1:30. I'm going to just put up we're at lunch on the screen, but we'll leave this Zoom link open.
Okay, Judge, have a good lunch.
You too.
Judge, are you gonna leave it on YouTube during the lunch break?
I was. Do you not want me to?
Yeah, because they want to. I'll go to the jury room.
Oh, I can, no, if you needed to talk, I can always restart the YouTube. Why don't I?
I'm gonna go in the back.
Okay. Mr. Pritchett?
Yeah. He can't dance it.
All right, you can bring him out.
Brace yourself.
This case with Ms. Taylor rolling off, and come on. It's not one that's going to plead out. Oh my.
Did you say Mansfield could go to a trial county, or did you not?
No, it should. It definitely should. And October, I think it was on October, that made the defense attorney happy. Yeah. Yeah, almost all of these are going to be, well, they'll be the plea party. Ms. Rivers, were you able to stay on?
Yes, Judge, I'm right here.
Thank you so much. Lunch break in just a little bit. Let's go on the record in Mr. Pritchett's matter, which is, just move my calendars around, 20 SC 176922, State versus Max with 2 X's, Pritchett. And originally we were going to have a status conference where I would hear from Mr. Granums, who had been appointed to represent Mr. Pritchett, about how things were going. But Mr. Granum shared with me that number 1, he had not yet received discovery. And number 2, more important in some ways, he had not yet had a chance to meet Mr. Pritchett. So I said, let's reset this. Then I got a note from one of the deputies that Mr. Pritchett wanted to talk to me. So here I am, and we are on the record. So Mr. Pritchett, good afternoon. It's August 5th. What do you want to share?
On the record, I believe there's been a mistake. Am I being forced to claim something that is not mine? Where is the proof again of evidence that legal name you're assuming me to be belongs to me? Also, on the record, let the record show that Michael Granums and any other false advocate forcibly and deceptively assigned by this court is hereby dismissed. Furthermore, is there any evidence that I am prohibited from having as my advocate and representative, Jesus the Christ, that is mentioned in the Holy Bible?
Okay. Do you want me to answer any of that, or you just wanted to get that on the record?
Can you please answer it? Can you please provide the evidence of both questions that was asked?
So I can answer the last question for you. The others, you and I have, this may be the 5th time we've had this conversation. I'm not an evidence supplier. The evidence would be something that the jury would hear, and the jury might well decide that you are not Max Pritchett, or you are Max Pritchett, but you're not the Max Pritchett who should have been charged in this case. But that's not something that I need to work through.
Where is the evidence? Does the prosecutor have the evidence? So can they please provide it?
So that's where we get to your last question about representation. Mr. Granham's won't be your lawyer if you want to represent yourself in concert with the Lord Jesus Christ. The Lord Jesus Christ, probably can't do a whole lot of advocating on your behalf because I don't know that anyone would hear what he had to say, but you are always free to represent yourself, and we can have a conversation about that at the appropriate time. But we always stumble on that first part where you want me to provide evidence. And I've explained that that's not my role in this process.
Whose role is that?
Well, the prosecutor has the burden of proving your guilt beyond a reasonable doubt if they're able to do that. And they either prove it to me if it's a bench trial, or they prove it to a jury if it's a jury trial. You've been through that before in your probation revocation, where the prosecutor proved to a judge that you had violated the terms and conditions of your probation, and you got the sentence you got from that judge. So we do a process somewhat like that.
Does the evidence exist?
I don't know. If it doesn't, then I know what the jury will do. They'll acquit you, and you'll just be working through your revocation. But I don't.
How can we proceed with anything on the record? How can we proceed with anything if jurisdiction and authority has not been established or proven beyond a reasonable doubt?
So it gets proven beyond a reasonable doubt at trial. That's when the jury decides if crimes occurred and if they occurred in Fulton County. If they didn't occur at all, or they occurred but it wasn't in Fulton County, then there's no more jurisdiction, and you get to go back to dealing with your revocation. But what we need to sort out is who would be representing you. You're telling me you don't want it to be Mr. Granham's, and we can make that happen. I'm going to have Mr. Granham's come meet you. You can tell him to go away or break bread with him or whatever it is you choose to do. But I need the two of you at least to have that initial contact. So he's going to come visit you, and then he'll, I'm guessing, share with me what you shared with him, which is what you shared with me. And then we'll get you back here and have that discussion about self-representation with the Lord as your standby counsel, which we can do if that's how you want it to work. Anything else you want to get on the record?
Just that if the evidence exists, can you please have the prosecutor or whomever that does have this evidence, that I am the legal name that this court is claiming me to be, and just please provide me with the evidence of that, and also the evidence, if it does exist, once again, of the jurisdiction and authority of this court, and that it does have jurisdiction of authority over the body and church of Christ, which is composed of individual members such as myself.
Got it. If you end up representing yourself, then the prosecutor is going to need to give you all their evidence. Once you get that, you'll be in a position to say, you know what, I think it's deficient, and here's what we need to do. But until we sort out that you're going to represent yourself again with the Lord as your standby counsel, the state needs to be working through Mr. Granham's. I heard you very clearly, no misunderstanding on my part, that you seek to dismiss Mr. Granham's. He's going to come talk to you. You can tell him the same thing. We'll bring you back and have that hearing about representing yourself. Okay? Good seeing you. Thank you, Ms. Rivers.
Okay, Judge.
Now, my advice would be you take your lunch break now before we come up with something else.
Hey, I'm leaving.
All right. $1:30. See you. So our afternoon stuff, I'm seeing, do we have some people who are in custody? I guess so. So if you guys want to do the swap out, go for it. You may have already been doing that some, but that would be great. Mr. Torres, was he brought over? And do you want him up, or is that not productive?
I
It
don't.
says loaned out to Georgia Regional, so I don't, but then it also says 3 North.
He's back, but he also requires a Spanish interpreter, but I don't think he's in a position that we would need to bring him out. I think-
Okay. Do you need him brought up? If he's in, I don't know that he's in the building at all.
I don't think we need him today.
Okay, if you just remind them of that so they don't bring up him if we don't need him. Or some of this is old, it lists Michael Webb on it.
You got it. Okay.
Can I help you?
I hope so. Thomas Rock with the District Attorney's Office, Judge.
Okay.
I was actually looking for Kate Charles.
She was here. She finished court this morning and she'll be back at 1:30.
Okay, I was going to ask her for your case manager's information so that I could get on your calendar.
She's right here.
All right, awesome. Can I get on the judge's calendar? I've been appointed the new deputy district attorney for non-complex. And Judge Brasher suggested, Your Honor, that I talk to you about what I'm supposed to be doing.
Is that what Mr. Rhodes used to do?
Yes, it's what Mr. Rhodes used to do.
Why don't you get on my calendar now? I need to finish this email and then we can go talk.
Oh, right now?
Yeah.
It works.
Yeah.
Thank you, sir.
How's that for service?
I love that.
Besides, the deputies want me out of the courtroom so they can do what they need to do. I just got to send this one email.
I'll see y'all.
I've never seen a judge handle something like that.
Business cards,
Right, you're official, very official now, right?
yeah, there we go. It's kind of like Facebook official on
I don't know what the red uniform. Well, you know, in Greer's cap, they worked. It was had something to do with the workforce.
We're outside looking and walk around and see what we're doing.
All right, they do. Yeah, might need that.
All right. You can come this way.
Yes, sir.
Thank you.
Thank you, Judge.
Yeah.
Thank you.
Got that phone, man. Come on, let's drop these photos. I got one that's cheap. Alright.
Where you come from?
Oh.
You staying?
I am. I'm hanging out with y'all.
Right. Make sure it's good, all right?
Thank you. Oh. Thank you so much.
Mr. President, you ain't trying to help me, see?
Oh, wait. Sorry. I was like zoned in.
Hey, early. So we got 5, 6 people up, so.
Okay.
you wanna talk?
Thanks.
Yeah, it's over there. Not here, yeah. We got, 5 people in today.
You doing all right? So he come back with all the action. You see that? Yeah. Thank you. I'm trying to confirm this time.
Oh,
But I'm trying to confirm it.
cheese. Okay,
So I'm like,
okay, thanks, because I didn't. Thank you.
You're welcome.
I didn't know you was back, but I thought you would do. No, I thought you got to eat.
Welcome back. Good call on the phone charger.
I refuse, by the way. I refuse.
What does he even have?
So before we got here, yeah, no, way before your time, like way before any of this, probably right before the pandemic, Miranda and Jordan. So Eric's unit used to be Eric, Rayona, and Miranda. And before they changed everything, that he did was prelims. So Miranda left and she had a massive like number of cases that she left. And then the pandemic happened. And so Liz was like, she divvied them up. This wasn't before like all the other cases that would take on. So like I had literally like 10 clients that I was so that's not true. And so thank God I did not get notice of this. I was just like cruising through the calendars and I was like, so
Ladies, just so you know, your mic is on.
thank you, Mr. Smith. So I'm actually, I'm not sure. So this case is actually from 2018, this is the statute of limitations. So we bonded out before I was going to file. Yes, but then he bonded out before because there was like how many times really at the time emergency orders. So we just saw that and then show up and argue it. She's sitting, so she's a matter she's sitting by designation. So I don't know what it is. Yes. Well, they're a whole bunch of things. So it's an adult, an adult. So they're not doing where this is the role of cookies. Is it past the interesting. I mean, yeah, I feel like yes. What the amounts are? No. No, but I usually just. Okay, yeah, so, the judge will likely continue more, we can. Should go out to but do you know? Or do you tell her? I mean, here. Oh, the time, yeah, he's very interested. I think this is. Yeah, that's gonna be very hot. Yeah, then he'll absolutely do this for you. I can write down like very good attorneys that I know.
personally, if you were to do that for you.
Well, I mean,
That is really about.
I wonder if that'd be.
What's that? He got another one or he has one?
Oh, there you go.
Okay, what about it? Whose case is that? Jamie's?
Yeah.
Okay. All right, I'll call you back. Bye.
Phenomenal. Yeah.
Cody, what's going on?
hey, I just wanted to call and tell you, I need you to switch that from being whatever that is to the PayPal.
The what?
PayPal?
Oh, you need to switch it to PayPal?
Yeah.
That's fine.
Okay, sir.
All right.
And I also sent you an email.
I saw the email.
Okay.
Hang on. You got to include Justin on these emails, okay? So let me forward this to Justin. Hang on. I just sent it to Justin, okay?
Okay.
All right. Thank you, man. Talk to you in a bit.
Yes, sir.
Bye. Hey, I want you to pretend that you're going to pay me in PayPal. Do you have a PayPal account?
I've never used PayPal before, Kevin.
That's even better. Hey, fuck. This is Brian. I'll call you back.
Okay.
Hey,
Yes,
Mr.
sir.
Fisher.
Yes, sir.
Yeah, I don't know.
Yeah, I can still hear you. Okay. Yeah, so you can put me in PayPal.
Hang on. Thank you, everyone, for listening to my conversation. I want to apologize.
You can hear you.
They said they on break this still on Thursday.
Okay. Yeah, that's turkey.
Hey, Carlos.
How are you?
Good. How are you?
Good. You have your.
Yes.
Same guy,
So,
right?
and my new trial partner actually took over. I don't think you
Haven't-
met her, right?
Oh, I
Okay.
don't think so.
And I can't remember if they told me he was brought up or not.
Okay.
So
Maybe
yes,
not.
maybe not. So yes, so stand by. He is number one on the calendar though.
Okay.
So
let me
we'll,
just
yeah, of
write it
course.
down. I
There you go.
remember
Yeah.
some of the name.
Yeah, that's
So I
fine.
figure that's him. Mr. Torres.
Yes, so I have a feeling judge might give us a new court date on that one today. Yes, thank you.
So he's still,
Yes. Mhm.
yeah, he's busy, that's right.
I know, a really long time. We talked about Torres is not up, right? Okay. Yes, so that should be relatively quick today.
Yeah, Well, last year, he got a little bit more coherent.
I
Yeah,
think
but
now it's kind of
it's gone
since,
back to-
mhm, yep.
Yeah, so. Yeah, I really forgot to pay them.
Right. I know.
No, we contacted, we not contact somebody in Florida.
Yes, and our,
Did they follow up with you all?
yes, and our social
Okay.
worker is on the call, so I think
Okay.
she has more of an update than
Okay.
I do, but yes, we did, because we did talk about that the
Yeah,
last
I
time.
recall that.
Mhm.
Is, you know, my daughter was the one who put me in touch with.
Okay,
her.
yeah.
She works, she's like a big boss with government. So I called
Oh,
her
nice.
And I asked her if she could help, and that's how we got that contact. Okay, that's probably something.
So yes, I don't think anything will happen with him today.
So,
Like somebody supposed to be.
Oh, I have no idea.
Hold on.
Oh, thank you.
okay, this is a status hearing, right?
Mhm, yes. Awesome, thank you.
Oh, I took you.
No, you're fine.
All right.
She could just hop on.
How long we're on the board?
It is, it's, so when they're doing their closing.
Wait, where's the new camera at? Oh, my goodness.
I'm so glad that wasn't there for my interview.
The Wild West right now.
It's on the original.
Hey.
Well, he was listed on the charter, yeah.
Yeah, exactly. Yeah, literally, it's literally that type of situation.
All rise. Report for the county general session. I'll observe Robert McBurney presiding.
Good afternoon. Please be seated. Sorry for the late start. Go. All right, we have a plea and arraignment calendar and a status conference calendar for this afternoon. I'm going to start with the plea and arraignment in part because our very first position is why we have Mr. Lares here. And that's Mr. Torres' case. Just set down for a plea, which you all have explained to me is not a plea. Did we confirm that he was not brought over today?
He was brought over, but I don't think he was brought up.
Not brought up at your request. Okay, so we don't need to keep Mr. Lares here any longer. All right, if I need to sign something for your presence, if not your hard labors, I'm happy to do that. Where are we with Mr. Torres? Is he been deemed competent again? I think we had a conversation with him last time he was here. And there was some back and forth. I'll just start with you, Ms. Feely. What's
So his competency was restored at Georgia Regional, but our issue has been trying to find a safety net for him to hopefully be released. And that's what Ms. Patterson has been working on.
okay? Ms. Patterson, do you have an update on Mr. Torres?
Yes, sir. Your Honor, we are about 75%, more like 80% complete with finding a housing option for Mr. Torres. He has been approved for housing through Positive Transition Services. He has been accepted to Viewpoint to their ACT team. So they'll provide community services for him. That missing piece is the DBHDD housing voucher. So that's the missing piece on that, but everything else, because he has to have the voucher in order to go to PTS because of the way that his referral was actually submitted. And so in order for PTS to get funded or to get paid, he has to have that housing voucher. There was some confusion. This process started actually back maybe a day or so after he was last in court. The holdup had been that the person that was originally doing those vouchers actually left Grady. And so finding someone else to assist in that process. They sent someone to the jail. And then this person says, hey, we can't find Mr. Torres. So then I had to provide where his location was. They went back to the jail, and then somewhere they missed that he needed an interpreter because he only speaks Spanish. So we were finally able to get back to the jail actually yesterday. I saw Mr. Torres along with the intake person from Grady, as well as one of our investigators who interpreted. Mr. Torres was very oriented. He was aware of what was going on. And so we just have to get that voucher. But again, we're about 80% complete in the process.
So the voucher is not anything I can assist with. It sounds like there were some administrative hurdles and someone in transition at Grady. Do you feel like you've got a bead on it and it is obtainable, or it's more complicated than that?
If I make the statement that the judge is very interested in having this done, then it can get done.
Okay, I'm pretty interested. This is a 2016 case that has gotten old through no fault of anyone. Mr. Torres is working through a number of situations. I'm grateful to Georgia Regional that they were able to restore him. I'm particularly relieved that you found him recently to be oriented to time and place, because we've all, many of us have experienced someone who is restored to competency, but they linger too long at Rice Street and things degrade a bit. So I would love for us to be able to strike while the iron remains competent. Maybe we can make something happen. What do you think, Ms. Patterson, is enough time to build in before we bring Mr. Torre back, and we will bring him back and up and have an interpreter present?
To be on the safe side, 30 days. I will add that I have a similar case with Judge Ingram, very same situation where an issue with voucher, and she did have to get involved in that. So we can have some conversation about, how you would be able to assist.
Good. Well, that's actually the basis for me asking, because she shared with me that there was an issue with that. When I heard you say DBHDD and vouchers, that's why, wait a minute, Judge Ingram was just having to deal with that.
Yes.
So I offer up my same services. I'm not as savvy as she is about DBHDD, but if there's something I can do to help, let's make it happen. DBHDD gave a rousing presentation at the judges conference, and they profess to be very supportive of things like this. So let's hold them to it.
Yes, sir. I would, and I don't know if this is something that you would be able to have some hand in. When I saw Mr. Torre at the jail yesterday, his presentation was not the best. And when I say presentation, the uniform that they had him in, there was no justification for him to be dressed in the manner that he was in. He was not in isolation. He had on see-through pants and everything. And so he was not on isolation. He was no threat or anything. So if we could address that, whatever that looks like. I asked why he was, typically it's if an individual is a threat to themselves or others. He has not been on any suicide watch. I was not able to find any incident report or anything. So no real justification for him being presented in that manner.
Got it. Okay. I will look into that. Ms. Feely, any objection to setting this out 30 days, about a month? Ms. Charles, probably won't be you bringing this one to a close. Have you been negotiating with the PD's office about how this would play out, or they have a proposal, you're going to have your perspective, and they may actually be somewhat distant?
No, Aaron, I think we're on the same page. It's a matter of finding, once we close out the case, releasing him into some sort of safety net, not just back on his own.
Sure. No. And I think we're all aligned on that. Just please make sure then that your file is annotated so that your successor, who is going to be a free-willed individual, doesn't say, I'm not familiar with any of this.
Yes, Your
Honor. Okay. And you'll be available to
Absolutely.
be dragged back in.
Around to help.
Okay. Good answer. Ms. Patterson, last thing on Mr. Torre, so I don't embarrass myself in reaching out to jail staff. You're saying basically he was wearing pants made out of cellophane or something?
It was more like a net, more like a fish net, like
okay, it's a net. Okay, and that's for safety reasons, etc. Okay, got it. One of the deputies here is educating me on that. All right. I will inquire about that. You inquire about the voucher, and we'll see where we meet.
Yes, sir.
Okay. Thank you so much. We are going to skip briefly to Mr. Lewis, number 9, because he needs to be back in Cobb County pronto.
Good afternoon, Judge. This is Attorney Bumpus.
Hey, Ms. Bumpus, how are you?
I'm doing good.
Good. He has two cases, it looks like. So we'll bring
He
Mr.
has 3, Your Honor.
3. Let me not understate things for Mr. Lewis. 3 cases. Look at that. 9 through 11. Okay. We'll get him out here and talk real briefly. Ms. Bumpus, do you represent him on all 3 of his Fulton County cases?
Your Honor, not at this time. I've only been retained for the first. It was a situation where he got out on bond on my case and got 2 additional cases. I have not been retained for those 2 additional cases.
Okay.
And to be clear, Your Honor, the case that I've been retained for is 22 SC 182696.
Got it. So you represent Mr. Lewis. You need to face this way, Mr. Lewis. You can look at the screen. You can look at me. Don't turn around. So Mr. Lewis has an aggravated assault case, family violence battery. The number you just read, Ms. Bumpus, that's position 9 on our calendar. He also has, this is plea and arraignment, so we may need to see if Mr. Lewis qualifies for appointed representation. He's got a position 10, another aggravated assault, and a weapons charge. And then position 11, another aggravated assault, and a battery against a pregnant female. And it sounds like another firearms possession. Are you on loan out from Cobb County, or you are being housed in Cobb County as a Fulton County inmate?
I'm being housed at Cobb County as a Fulton County inmate.
Okay, so why? It's just that they need to get back to Cobb. Okay, got it. So you have 3 cases. They're all Fulton County cases.
Yes, Your Honor.
Great. All right. So Ms. Bumpus, who you can see on the screen there, and I will try to make her a little bigger so you can see her better. Mr. Lewis, let's do that. There you go. There's Ms. Bumpus. She represents you on the first of the 3 cases I mentioned, but you've got these 2 other aggravated assault cases as well. They were indicted consecutively. They have consecutive numbers 696, 697, 698. Ms. Charles, I know you don't do the indicting, but do you have any familiarity with these cases? Are they connected in some way other than obviously Mr. Lewis? All right.
Yes, Your Honor.
Mr. Thomas.
What was the question again, Your Honor? I'm sorry.
Rarely do I get a defendant with multiple indictments where they are consecutive numbers. That says to me that someone from your office got in front of the grand jury and said, we've got 3 cases on Mr. Lewis, and the same grand jury at the same time was hearing about, I mean, they may have heard them consecutively, but in that same sitting, they heard about all 3 of these cases. Is other than the fact that they're domestic violence cases, are they, is it the same alleged victim in all 3?
Yes, Your Honor. So they all the
Same
Okay.
thing.
Same victim. And that victim has what alleged connection to Mr. Lewis? It's the girlfriend, wife, mother of child?
Girlfriend, mother of child, 2
Okay.
children. One child was born, and I think one of those is the cruelty on one of the cases, and one child has been born since he's been in jail. That's
Okay.
the pregnant woman.
Got it. Okay. That helps orient me. Okay. So, Ms. Wood or Ms. Feely, do you have a sense of whether Mr. Lewis would qualify for representation from your office on the 9-7 and 9-8 case? And I can understand why you would not have spoken with Mr. Lewis because he has an attorney of record who is a retained counsel on the 9-6 case.
Well, Judge, when I looked in Odyssey under the first appearance court action from first appearance, they had listed the conflict defender office and Yvette Hill as representing him. But I'm not sure if that was I'm not sure if that was actually the case or if, I know the conflict defender had him on the first case that's Ms. Bumpus has been hired for because Ms. Hemingway had filed a leave of absence.
Your Honor, if I may, what happened was, I filed the motions and entry as a CP and not under the SC. I recently filed it under the SC today, but I was retained after the first appearance of this first case, and I was able to get a consent bond through the with the DA's office, because this is a case, not to go too much in detail, that does have some mental health issues, and I have spoken with the state briefly. I'm not sure if it's the same ADA, but I did previously, and we were looking into some different possible resolutions that are on a mental health track.
Okay. Ms. Bumpus, do you think that it is a possibility? I don't know if it was Mr. Lewis who reached out to you or a friend or a family member, that you will be retained to handle all three, given that they are in some ways factually a package, same alleged victim. I don't know how far apart they're separated in time. They're obviously not separated in time in terms of indictments.
Months and weeks.
Okay. Do you think that there is a chance you'll be brought on board for the other two, or
I do think there's a chance, Your Honor, not to cut you off. I have spoken with the family and I have told them the seriousness of 3 cases with the same charges, and it's just a matter of if they're willing to make that financial commitment. Like I said, I had been paid for the first case, but I wasn't willing to put myself out there based on the nature of the charges.
Sure. And I may have misheard you. You have been paid for or you still have not yet been paid for the first one?
I have been paid for the first one.
Okay. So you're official on board 100% for the 9-6, and you have chatted with Mr. Lewis's family about perhaps also being brought on board financially and thus professionally for 9-7 and 9-8.
Yes, Your Honor. And I hope that's something that we can work out, because the ADA who I spoke with, we were getting close to, wrapping something up.
Okay. Today is plea and arraignment, at least for the 9-6 case, the one for which you have filed an entry. Were you going to be waiving arraignment for Mr. Lewis, or was I going to be formally arraigning him today?
Yes, Your Honor. I also filed that waiver of arraignment, but I'm sure it's not showing up in Odyssey yet.
Okay. Let me see. I've got Odyssey here. You're right. So you did that. So your entry, and you are listed as lead attorney, but that's because you were plugged in earlier. But you'll file that entry, and you've done the waiver of arraignment for 9-6. What we'll do is get a scheduling order in place for 9-6, and I'm going to ask Mr. Thomas, who will be replaced as of tomorrow by Mr. Whitenauer, to get you, Ms. Bumpus, discovery in all 3 cases, not because I'm expecting you or appointing you to be involved in 9-7 and 9-8, but if you are going to try to arrange a global resolution for Mr. Lewis, you ought to have access to those materials. And it sounds like there's a possibility you could be brought in as counsel for the other 2.
Yes, Your Honor.
Okay. So we'll get that scheduling order out. Mr. Lewis, you have listened very patiently. Do you have any questions about what we've been discussing?
So there's actually been a lot of confusion. I haven't actually seen my discovery.
Okay. Well, you can't see it yet because your lawyer doesn't have it.
Okay.
Ms. Bumpus will be getting it. I mean, she may have the indictment or something, but that's the very thin edge of discovery. The state will be getting to Ms. Bumpus if there are police reports, if, let me put some context to this. If Ms. Gray gave a statement, if there was a firearm taken in, I mean, all that kind of stuff, the state will be providing, not the gun, but a picture of it, whatever they have in connection with your 3 cases. Ms. Bumpus will get that. She's going to digest it, and then she will share it with you. When you're in custody, she can't give you a DVD if it's a recording of a video or something, but she can tell you, I listened to Ms. Gray's statement, or there was a surveillance camera and it shows you with an axe in your hand, or whatever is on there. She'll share all that with you. No one's keeping it from you. It just, the state hasn't had a lawyer yet to give it to, because it doesn't happen until after today, this arraignment date. So that was confusion number 1. What else you got?
Well, the thing is, because of, everything, I haven't even really had a real opportunity to have a decent conversation with my attorney. This is actually my first time, seeing her. But I mean, because I'm housed in Cobb County and I don't know how all that is, but is there a way that maybe I could talk to her today?
So I don't know about today, but Ms. Bumpus can tell us, you and me together, when she thinks she'll be able to get to Cobb County to meet with you. I know that visitation can happen for lawyers and clients at Cobb County. Ms. Bumpus, when do you think you'd be able to connect with Mr. Lewis?
Yes, Your Honor. I was waiting on the discovery and a little bit more substance between the conversation between the state and I, because I don't like to make trips to the jail in vain and waste anybody's time and not be able to answer their questions. So
sure.
I was actually waiting on this day, discovery, and some other things. Because before then, I had nothing to tell them.
Okay, that's a fair point. So the state has an obligation to get to Ms. Bumpus just in the next few days, the discovery, at least in the 9-6 case where you have Ms. Bumpus. She wants to get that so she can, as I think I use the term digest, process it, read it, so that when she comes to meet with you, not only can she give you paper, but she can say, look, I've looked at this and the state has a terrible case. We need to fight this. Or you're going to need to explain some things to me, Mr. Lewis, because I read through this discovery and you've got a complicated situation. You guys need to have that kind of exchange. But Ms. Bumpus understandably wanted to get that information. And it sounds like she's already had a couple conversations, if not with Mr. Thomas, who is standing right behind you, a colleague of his, about ways in which your cases might be worked out. And the more it was with Mr. Thomas. Excellent. And we've got all the right people in the room. Your lawyer's trying to figure out what's the state's angle on this. Are they looking for 100 years in jail, or are they looking to get you some help? Maybe there's a anger management situation here. I don't know. I don't get in the middle of those things. I just handle it when people have either agreed or they've agreed to disagree. And your lawyer will ask for this, and the state will ask for that. So it sounds like to me the answer is Ms. Bumpus is ready to see you once she gets discovery and can talk with the state a little bit more. And then when you start asking her the smart questions you're going to ask, like, how are we going to work this out? She'll have good information to share with you. Okay.
Understand.
Anything else?
Yeah, I was trying to figure out a lot of the bonding, the information. I don't have one now. I was wondering what would need to be done in order to.
So you'd need to talk with Ms. Bumpus.
Right.
If she decides if she's retained to represent you on the other two cases, she could file a bond motion. Right now, you don't have lawyers on those two cases. If you can't afford a lawyer for those, I'll appoint one. It's not a situation of you better come up with the money or else. I just don't want to give you two lawyers right now, since you've retained one, if there's a possibility that Ms. Bumpus is going to handle all three cases. But we'll be talking again soon. And if Ms. Bumpus says, look, it doesn't look like these are going to work out right away, and I'm only hired for the case ending in 9-6, then we'll figure out, is it the public defender's office or the conflict defender's office? Who can I appoint to be your lawyer on those other two cases? You'll need to meet that person, talk with that person about discovery, et cetera. That's the person, whether it's Ms. Bumpus or this other lawyer, who would say, hey, let's get in front of the judge and talk bond. I will tell you, someone with 3 cases with these kind of charges, bond is not going to come falling out of the sky into your lap. But it doesn't mean we can't have that discussion. Okay?
Yes, Your Honor. So as far as payment to Ms. Bumpus, that's all being worked out right as we speak.
Okay, Mr. Lewis, I'm gonna come talk to you, or you can give me a call, but let's not take up the court's time with these questions, and let's let the court move on to the next case, okay?
All right. Ms. Bumpus, anything else on your client's behalf, at least in the 9-6 case?
No, Your Honor.
Okay. I'll get a scheduling order entered once we see your waiver of arraignment hit the docket. Mr. Thomas, will you be getting discovery to Ms. Bumpus, or are you going to be letting Mr. Whitenauer know Monday morning he's got a project?
So, Your Honor, I'm going to initiate discovery today, and then I just want to carry over to Mr. Whitenauer. We'll both be on it.
Fantastic. Okay. All right. So, Mr. Lewis, I think they need to get you back. Ms. Bumpus, anything else?
to seeing you. That concludes my business, Your Honor. May I be excused?
Yep, have a good weekend. Cool.
Thank you.
Was there anyone else, Deputy, you needed us to do? That was it? Okay. So Ms. Wood, were you able to tell, I didn't follow 100% what you were saying, that maybe a conflict offender had popped in at first appearance for Mr. Lewis on one of the other cases? I couldn't find there was first appearance court action, but.
Right, there's no entry, Judge. I
No.
just looked where Judge Hughes had put in Heel, who was, I'm not sure if they're still there, but there was an Yvette Heel, and her number that was listed on that piece of paper was aligned with Metro Conflict.
Okay,
I'm not sure if that person is still there or not.
got it. I guess. It did say for 9-6, which is the case Ms. Bumpus has taken, it does say Fulton County Metro Conflict Defender. Doesn't have a name, but it says that, doesn't say your office, it says that office. So the other two may end up being Cladis Productions if hopefully Ms. Bumpus just gets brought in. All right. I just don't want to lose track of the other cases. Okay, back to the regular order. Raheem Conley.
Judge, he is actually in custody on an unrelated matter. However, I spoke with him over the break. He agreed to allow me to go ahead and do the waiver, which I've already filed, so that he could go ahead and get transported back.
He is in custody in what jurisdiction?
Fulton. It's on a different case. I'm sorry.
Okay.
Yes.
So I have two cases with him. Does he have a third case?
It's going to be a misdemeanor, so not with us.
Okay.
Yes.
And that's what he's in custody on, or does he also have no bond in the 22 SC case? It just doesn't list whether he has a bond on that one.
I'll double check, Judge. I know that he was picked up on the misdemeanor. He was out on bond on these two cases.
All right. So I don't want to surprise anyone. Well, take a step back. The 21 SC lists Mr. Webb as his lawyer.
Judge, this is one of those instances where there was a conflict on the 21 SC. So now that's Mr. Cladis. When I submitted the paperwork for the 22 SC to go along with that one, it was rejected.
Okay.
I
Right.
explained all that to Mr. Conley, and I'm also looking into an issue. He has an ankle monitor still on so I'm working with the company on that, but he was here, Judge.
Okay. Meaning he was produced, you're just not needing him to come out here. He's going to waive arraignment on the 22 SC.
And I believe Mr. Cladis may have done the waiver on the 21.
Okay, great. Waive and schedule. So I'll work with Mr. Cladis. I'm going to evaluate whether the bond ought to remain on the 21 SC case, given that there's a new arrest on the misdemeanor side, just so Mr. Conley's staying in one space while we work through this. And he's got, I guess, maybe 3 lawyers across the 3 cases. All right. Thank you. Catherine Sanders. Hello. I'm all right. So I got to meet the other 2 people named in your case. Mr. You were with Mr. Paul. Okay, so you heard me mention your name. Got it. So we need to figure out what's going on with representation for you. You had, I think it was Tracy Reeves. And why was it that Mr. Reeves, why did he stop being your lawyer?
They did so I paid him majority of the rent. I just had like a $2,000 payment that I didn't pay.
Yep.
And I told him, I was going through a lot. I got 5 kids, all this other stuff. But he still just ultimately just fill out the case, and I still didn't get my money back at all. I paid $5,500 of the $7,000. He gave me $1,000 back.
What did he do for you for all that other money?
Nothing. This case was December of 2020, and it just got indicted in March of this year.
Yeah.
And
Okay.
then when I first came to my plea arraignment, he had COVID, and then he dropped out the case. So it actually was nothing.
Okay. Well, you ought to keep working with him on that. It sounds like you maybe do some more money. They want to reach out to the state bar, let them know you do some more money. But I'm going to stay out of it.
Reached out to conflict attorney as well, and I also tried to reach the public defender's office. The conflict interest attorney I have not been able to get back in contact with at all. The numbers that I have, there's no way for me to leave a voicemail. One number is actually disconnected, and then I also actually sent an email as well to no reply at all.
What email address did you send something to?
It's JA request, I believe. Hold on one second. Magistrate.ja request at Fulton County.
I have no idea where that goes. I'm not surprised you didn't hear back about getting a lawyer.
It was, I think on their website, they said that you're not able to reach us via phone, you can email it.
That's fine. So let's talk about who can represent you. So Mr. Polio, the first appearance court action listed Ms. Bando. So Ms. Bando has represented Mr. Polio throughout. He has retained counsel. Is it Mr. Stewart? That's your client. So you cannot have the public defender. So it sounds like you would be the conflict defender. Any reason the public defender's office can think of as to why that would not work? All right. So I'm going to give you his name. I don't have his phone number, but we will let him know that he needs to connect with you. How's he going to reach you?
Via phone, email, either. It really doesn't matter.
So we may need to get your contact information. You don't need to say it out loud, but you could write it down and get it to Ms. Nelson so that we can get it to Mr. Cladis. Cladis is the name. Do you want to write that down, or you're just going to remember? Okay.
Actually trying to see if he can be my C3 lawyer. He was trying to see if he can reach out to someone in the conflict office to see if, since it's backed up and things like that, if he can be on board to be my C3 lawyer.
Got it.
But he hasn't heard anything. I haven't heard anything, and I know that, we want to get this.
Yeah, and that whole C3 thing's not working real smoothly right now.
Yeah.
So we'll figure out if Mr. Cladis can represent you. He should be able to, I think. Because here we actually know who's representing the alleged victim in the case too. So if you don't mind writing down, there's some note cards right there. The deputy can get you one of these note cards. And if you just write down your name, and then you can choose phone number or email or both. That way Mr. Cladis will be able to reach you. And then we're going to try to get your case moving at the same pace as Mr. Polio and Mr. Stewart's. Ms. Feely, your understanding is that Ms. Sanders would fall into the Polio category and not the Stewart category. Okay. How many firearms were allegedly involved?
I think 3.
Okay. Got it. Ms. Charles, anything you want to add in Ms. Sanders's situation?
No, Your Honor, just stand by for an update.
Okay. Me too. That you get it. Perfect. Thank you so much. All right, Ms. Sanders, you are free to go. You should reach out to Ms. Nelson if you've got any questions. We'll connect with Mr. Cladis, and assuming he says yes, one, he'll reach out to you, but two, we're going to get you back real soon on this calendar because this calendar is just about getting your case moving along. Okay. Did you get something in the mail about being here? Okay, so we've got good contact information for you. Well, plus we've got what you wrote on the card. All right, thank you so much. You too. So next is Mr. Staton or Staton, and I just got an email about him. I'm trying to, he is there. Where is there?
The next email says, Mayor.
I think that's Arizona.
Oh, Maricopa. That's Arizona.
Yeah.
Okay. All right. So Mr. Staton's not going to be here. He is in Arizona on 2 cases, and he's got bond. Boy, ag assault on a corrections officer, and they gave him a bond. And then ag assault on an officer, attempted disfigurement. What is he wanted for? What does he got here? Obstruction, terroristic threats. Okay. He's got court in Arizona in 13 days. Ms. Wood, Ms. Feely. All right. I am going to try to get, and you may as well, and maybe Ms. Charles can help, little information about Arizona, when it happened, et cetera. I don't know. Let me look one thing up. There's a W. Yeah. Is that the Arizona thing or something different? Our warrant. Okay. I wanted to see how old this is. So this is something that happened over a year ago, but the indictment is recent. If this Arizona stuff is more recent, I'll probably have his bond go away here until we can get him back and work through what's been going on. But I'll need to get confirmation about the Arizona stuff. And we have to hold off on the arraignment. I guess, Ms. Feely, one thing you should think about, depending on what's going on in Arizona, we've done this before, if we can connect with the Maricopa County Jail and have him appear virtually, if the Arizona situation is going to result in a, making the numbers up, 5-year plea, I bet Ms. Charles or her successor could come up with a way to have this fold into that. We just take the plea virtually, rather than the whole process of producing him here to then return him for a concurrent sentence. But no arraignment yet. This is sort of in limbo. Who figured out he was in Arizona? You did?
I got a call and I researched it.
All right.
I started researching over the past.
Stanley Porter.
Yeah, he's in custody. I spoke with him at the jail earlier this week, and he does not wish to be represented by my office or an attorney at all. He wishes to represent himself. And I told him that you would have some questions for him today.
Sure. Let's bring Mr. Porter out, please. Mr. Shapiro, your case?
It is, Judge.
Did Mr. Whitenauer tell you, well, I guess this is he wasn't in that. He had a pro se trial, his first trial with me. Interesting trial for him.
Thank you for the understatement, Judge.
Oh, he's here. I didn't say anything bad about it. He did great. In fact, I just had to give a review to his supervisor. Said he did a great job with the difficult case, which is why he got kicked out of the unit, I guess. Hey, Mr. Porter.
Hey, how are you?
I'm all right. I'm Judge McBurney. I don't think we've met before.
No, sir, I ain't met nobody yet.
Okay, well, now you've met Judge McBurney, and I've met
nice to
Mr.
meet you.
Porter. Mr. Porter, your case, you've been indicted for a few things. It's been assigned to my division. And today was the day for your arraignment.
Okay.
Do you know what an arraignment is, or should I explain?
Yes, sir, I know
Okay.
exactly.
You know what an arraignment is. Ms. Feely, who is with the Public Defender's Office, told me that she or one of her colleagues chatted with you, and you explained that you are not interested in having the Public Defender's Office represent you.
No, sir, I'm not.
And it's nothing personal. You, in fact, don't want anyone representing you except for Stanley Keith Porter.
Yes, sir.
Is that correct?
Yes.
Have you represented yourself before?
Yes, I have in habeas corpus in the federal courts and in the state courts as well.
Okay. You have a right to represent yourself.
Yes, sir.
We're going to have a conversation about that. I need to get a bunch of things on the record. We're not going to do it right now. We may do it today if time permits, but it's an extended conversation that you and I have to have. I wanted to at least connect with you to let you know I hear you loud and clear that you want to exercise your right to self-representation. I think we should be able to fit it in today. If not, we'll get you back here soon. It's called a Feretta hearing. You probably already know that, but we have to have that. I can't grant your request until I make certain findings that you understand the consequences of self-representation, and that it can seem to you like I'm trying to talk you out of it. I'm neutral in the end. It's your right. It's not my right.
Yeah.
But I'm going to lay a lot on you about how it's generally a bad plan. But as long as you are responding in a way that shows me you understand the risks, the downsides, et cetera, of self-representation, I'm obligated by law to let you exercise that right. And you're not in your head. You've clearly been through this before. But then that means you appreciate the need to do it. If we have that hearing and I grant your request, then you are going to be counsel for Mr. Porter, for yourself, from here on out. So hopefully we can do it today. If not, soon. I'm going to ask the deputies to take you back there, but to leave you up here just in case we can fit it in before we need to wrap for the day.
Okay.
Any questions about anything I've just said?
Not at this moment.
Okay, sounds good. We'll see you hopefully a little bit today. All right?
Okay, thank you.
You bet. All right, next position is Brian Marshall.
Yes, sir. I don't represent Mr. Marshall, but I have been in touch with him as Ms. Nelson has as well.
This is Brian Marshall? Hey, Mr. Marshall.
I've given him some names of attorneys. He does not qualify for a public defender, so we were hoping that Your Honor might reset him to allow him time to.
Sure. So Stephen Lang is a colleague of yours and worked with Mr. Marshall initially. Sure. Since then, there's been a financial assessment done, and Mr. Marshall's going to need to retain his own lawyer. Okay. Mr. Marshall, if you don't mind coming up to the podium. Are you?
Your Honor.
Hey, good afternoon. How are you? Are you employed right now?
I am. Yes, sir.
Okay. What do you do?
I'm a software engineer.
Okay, great. You are going to need to go about hiring your own lawyer because you are a person of means. That does not mean that you are Jeff Bezos. I'm not either. But we're both above the level of income that would trigger appointed representation. I want to make sure you've got some time to get a lawyer. But I also want to avoid you and I are talking every couple of weeks. You're like, yeah, I'll get to it, but I'm kind of busy. It needs to be a priority, but it also needs to be a lawyer you're comfortable working with. So tell me how much time you'd like so that I can reset this and get you back in here with that lawyer, because he or she will file an entry of appearance. That's a magic signal to me that, great, there's a lawyer in place. I'm assuming you want a lawyer. I was just talking with Mr. Porter. He does not want a lawyer. He wants to represent himself, but
not me.
Okay. Wise man. So you need a little while to find someone. What would you say?
I a couple of months, a few months.
Okay. What I'll probably do is set it out to late September. So it'll be around 2 months. You should get on it. And hopefully when we next connect, it will be with your lawyer by your side. Maybe one reset if you've got a real good explanation as to why it didn't happen. But now that I know you're gainfully employed and continue to be so, there are good lawyers out there who can assist you in this process. So you can start working on that. Let me make sure we've got a good way to reach you because it won't be through the public defender's office.
The 3410.
Yep. Alexander? Yep,
Yes,
perfect. You will get stuff in the mail there. We don't call. If anyone calls you, it's not the courts. We do not call folks. So you'll get something in the mail that is a notice to be back here. It'll be this courtroom. It'll be late September-ish. Can't guarantee you the specific date yet. And you'll need to be here by then. And ideally, a lawyer will have filed an entry of appearance on your behalf, and then that person will be here. And then we'll work through what we were going to do today, which was just your arraignment, where your lawyer will say, Mr. Marshall enters a plea of not guilty. I find out who the prosecutor is on the case. Who would be on this case, Mr. Shapiro? Position 7. I just don't know who handles counts 1 and 2. Is that Ms. Winfrey?
Yes, Judge, I believe it would be.
Okay.
Let me take a look and see.
Well, this isn't your problem. A prosecutor will be here. You'd enter a plea of not guilty, and that mystery prosecutor would start getting discovery to your lawyer, and we'd move forward. Does your bond have any special conditions? You're not supposed to be in certain places or this or that?
Yes, just the
whatever they are, keep complying with them.
Yes, sir. This happened
long ago?
Two years ago.
These cases, for some reason, the nature of you have an interesting mix of charges, and I'll learn about it later, but they don't necessarily, in my mind, fit naturally together.
They don't.
Sure, there's a story behind it, but the first 2 charges are the kind that, for whatever reason, move slowly through the pipeline. But now that you've been formally charged, I get to make it move at a more realistic pace. So once you get a lawyer in place, that lawyer will get discovery and we'll make things happen. So please get to work on that. Do you have any questions about any of the things we've discussed?
I do not, Your Honor. Thank you.
Okay. Mr. Shapiro, any confirmation? It's a Winfrey production?
Judge, we're actually trying to sort that out right now. In our system, it's listed as Ms. Charles, but I think because
it's always Ms. Charles. Okay. Doesn't matter for Mr. Marshall's purposes. He's got to go find his own lawyer. I just wanted to know who that person should be reaching out to.
And I'll try and get that information.
Okay. Sounds good. If you don't have anything else, Mr. Marshall, you're free to go.
Thank you.
All right. Have a good weekend. Gerard Hanna. I think I saw Mr. Jones on there. Mr. Jones, you still there? How about Mr. Hanna? Is he's in custody? Is this a Whitenauer / Thomas case because of the 3rd count? Okay.
Judge, I'm back.
You're back. Excellent. Just in time. Let me put you on the spotlight, and then we've got your client. All right. Mr. Hanna.
Yes, sir.
How you doing?
I'm doing good.
Good. I'm Judge McBurney. Your case has been assigned to me. Your lawyer, Mr. Jones, you should be able to see on the screen right there. He can see you.
Yes,
today is your plea and arraignment day, where I find out from Mr. Jones if he's waiving arraignment on your behalf. That'll trigger a requirement of the state to get discovery to Mr. Jones. He can come see you, share that discovery, and we can begin the process of figuring out, is this a trial? Is it a plea? Is it a dismissal? What's happening with the case? Right now, that would be hard to tell. Mr. Jones, is Mr. Hanna waiving arraignment?
Yes, Your Honor. And we plead not guilty. And I'll file appropriate motions.
Okay. So,
and Judge, there's one other thing. I filed back in June a bond motion pursuant to 17-7-50. He was indicted after 104 days after his arrest.
Okay. Well, sounds like something that we'll need to hear. It is not on the calendar for that. I'm pulling up the case right now. So there was a bond hearing. I see what you're saying. So there was a bond hearing in April and no bond was set, but then the clock ran out, if you will. And your motion flags that fact. Okay.
Yes, Your Honor.
All right. Well, we need to set down this for a bond hearing ASAP so that the state has a chance to be ready for it and whether there is a legal defense to your invocation of that statutory provision or who knows what. So we will do that. You will file a waiver of arraignment.
Yes,
do you have, we have a standard form. Do you need that sent to you? Do you already have one?
No, I have a waiver of arraignment in my system.
Excellent. If you would e-file a waiver of arraignment, then by the time it gets filed, it will be Mr. Whitenauer, who is replacing Mr. Thomas in the unit that will be handling Mr. Hanna's case. And then we'll set this down for a bond hearing for you and Mr. Whitenauer and Mr. Hanna to be here. It's possible that the bond hearing could happen sooner if Mr. Hanna is willing to appear virtually rather than in person. I don't know that that's the case. It may be that we can have it sooner in person than we can have it virtually. We have one day each week for both of those approaches. Mr. Jones, would you be willing, and we can get Mr. Hanna's affirmance on the record at the time of the bond hearing, would you be willing to go forward with a bond hearing with Mr. Hanna appearing virtually rather than in person?
Yes, Your Honor.
In other words, you'll take first available.
Yes, Your Honor.
Okay, got it. Mr. Thomas, anything in Mr. Hanna's case? All right. Mr. Hanna, did you follow everything we were talking about?
Yes, sir.
Okay, so I will see you soon to talk about bond. You may, I'm not promising yet, but you may be entitled to a bond with a number on it rather than no bond because of when you were indicted, meaning how long it took. But the state needs a chance to research that and respond, and we'll have that bond hearing. Again, if Mr. Jones is legally correct, it means I have to set a number, a dollar amount. May not be a dollar amount that makes you real happy, but at least is a dollar amount, which is a whole lot better than no dollar amount.
Yes, yes.
And we'll sort that out when I see you next. In the meantime, your lawyer is going to file that waiver of arraignment. He'll start getting discovery so he can talk with you about what the evidence looks like in this case. And we'll, take it from there. Okay.
Can I say one thing?
So in some respects, you can say whatever you want. If Mr. Jones were standing next to you, he would say, don't talk about the facts of your case.
That's what I was about to say, Judge.
Yeah. See, it's like I know him. So if it was going to be, hey, this case isn't so serious, or I only shot him once or something like that.
Oh, no, I want no shooting. No,
okay. I didn't say you shot anyone. That's what, but so were you going to want to tell me about the case, or you just wanted to say like, hey, I've been in jail a long time and I don't like the jail?
I wanted to take care of the case today.
Okay. That's a Mr. Jones and Mr. Hanna conversation. I don't know that he would counsel you to take care of the case today. But
in fact, Judge, my advice would be opposite of that.
Okay. So
I need to see the discovery, Mr.
Yeah, I think that Mr. Jones is saying you need to know what the state has before you say I want to plead guilty, because if it were to happen today, it probably would be a blind plea. It'd be particularly blind because your lawyer hasn't seen the discovery, but you might ask your lawyer to ask for probation. And Mr. Thomas might say, I'm going to press play on this video and I see something, I'm going to give you 100 years. And maybe Mr. Jones, working hard on your behalf, would have been able to keep the video out or who knows what. So I know you're anxious to move this forward. You've been in for a while. Let the process work for a little bit. It will move faster now that you've been arraigned.
Okay.
So I will see you for a bond hearing. Your lawyer is going to start getting discovery and we'll take it from there. Okay. But when you see Mr. Jones next, have that conversation. Like, I think I want to work this out. Mr. Jones can look at the discovery and say, we better work it out because a jury doesn't need to see this or who knows what. Okay. All right. Thank you, everyone.
Thank you, Judge. That's the only case I have. May I be excused?
Yes, sir.
Have a good weekend.
You too. All right. We already did Mr. Lewis because he had to be rushed back to our alternative holding facility, which gets us to Jason Sherman. Hey, Mr. Sherman, come on up.
Have you talked to people about the fact that they did W right there?
It's the same guy. Okay. Hey, Mr. Sherman, how you doing?
All right.
When I saw you last, there was a lot of drama because my calendar still says that you had a warrant. And we cleared that up.
Yeah.
So we're not going to go through that drill today. There's still a W. So I was just saying, but this guy's got a warrant. Why? But I don't remember what the false alarm was. We don't have that issue. But sort of like Mr. Marshall, last time I saw you almost 2 months ago, we discussed the need for you to go hire an attorney.
Yes, sir.
And
I've been calling the public defender's office. I didn't make it clear. I was working temp service jobs and I didn't make it clear. They didn't approve me. They didn't approve me for that. So the last 3 weeks I've been calling the public defender's office. They gave me 2 names, but they haven't got back in contact with me.
Okay. You have 2 cases. Got it.
Mm-hmm.
Did either of you, Ms. Feely or Ms. Wood, have a chance? You wouldn't have known you needed to speak with Mr. Sherman today?
No, Your Honor, and I have not gotten any message. No messages have gotten to Ms. Wood or I.
Okay. I don't know that Mr. Sherman would have known to call either of you directly. He may have been calling 1-800 public defender. Do you mind having a brief conversation with Mr. Sherman about his eligibility? It sounds like his work situation is a little fluid.
Judge, I'm happy to speak with him. I'm just trying to sort through. On Odyssey, there's a number of open cases. There's a 22 CP 206900. Judge Manning wrote on first appearance action that it was a conflict, but I'm trying to sort through what that conflict would be. It appears all of these cases have the same complaining witness. So I would like to look at that before I speak with him, Judge.
Okay. Fair enough. Meaning Carlos Sherman. Okay. All right. So Mr. Carlos Sherman is a relative of yours?
Yes, sir. My older brother.
Okay. All right. Got it. So Jason Sherman, if you don't mind taking a seat, I'm going to let Ms. Wood do a little more research. She's just trying to figure out not whether you qualify economically, but whether you qualify, is there a conflict? And so theoretically, Carlos Sherman may once have been represented by the public defender's office. If he was, they cannot represent you because they may have information about Carlos that they got because of a privileged relationship that they had that means they can't then represent you. So they're going to look at that a little bit. But what you're telling me is right now you don't believe you could afford an attorney?
Yes, sir. I talked to a couple of guys, and in the process of talking to them is when, like I say, it's only a temp service job. So in the process of talking to them is when those jobs ended.
So when did you last work?
Maybe like 3 weeks ago.
What kind of work were you doing?
I do warehouse work through the temp service.
Okay, so classic temp work.
Yes, sir.
But warehouses are humming along. Why can you not find any warehouse work now?
but last time me and you was here, I have 2 ankle monitors, remember?
Yes,
And-
yes, that's right. This is why we thought you had a warrant. So they see all your ankle, all your hardware, and they think, you know what? We'll just take the next guy in line.
I have 5 kids. I have you see my record, my family, I have 5 kids, a house. I'm going through the divorce and back with my family and my brother, and you see my record, sir.
Okay. All right. Then if you don't mind taking a seat, let's figure out whether the public defender's office can have that conversation with you. If not, there's a conflict defender. So it's not that you can't get a lawyer. It just won't be one of these 2. Okay.
All right.
All right. We'll come back to that. All right. Status conference. Our first case is Camoris Parks. Oh, but we're not going to do that. Don't bring Parks out. What did Mr. Cladis say? I have his piece of paper here. Parks. I'm on vacation. Mr. Abate, you're here. You are here. You served a large amount of discovery in February. None of it ended up in the file I, Cladis, inherited. It's basically he wants discovery again.
I've done half.
Okay. I don't know if we've talked about this case before. Is it, there are a number of defendants. We'll be meeting some of them soon. Is it a lot of discovery?
It's just a lot of videos.
Okay. So you're having to just sort of get your arms around it and push it through the portal.
Yes.
Okay. So Mr. Cladis does have the case, and you may well have already served discovery, but it went to Mr. Terry and then not from Mr. Terry to Mr. Cladis. All right. Thank you. Hope Mr. Cladis comes back. All right. Position 2 is Demario Phillips. Is he here? Don't bring him out yet. I just want to know if he was here. Okay. I'm afraid to look it up because I think, yeah, thanks. That always count on Abate to just lay it out there.
I will have the link ready for the new attorney on that case as well.
Okay. It cannot be. So why is it that the public defender's office has the defendant who is basically going to get a misdemeanor in this case and not federally? The federal defender would always say, give me the guy or gal with the most serious charges. You guys have false statements?
Judge, if I may, this was before our time. But
I know.
To inform the court that they have changed. It was by alphabetical order. It's been changed. So this.
Now you do it by charge?
I believe so, Judge.
That's a good change. Came a little late. All right. So Mr. Phillips needs a lawyer. That you agree, Ms. Upshot? I just was going to see if she did her withdrawal. She was thorough about that. I never met her. She tried a case as her last thing here. Just not here. Yep, she's off. All right, let's bring Mr. Phillips. Is anyone here for Mr. Phillips? All right. So we'll bring him out and we'll talk about the situation. Sure. Is Carrie Henderson here? Carrie is a she? Okay. Hey, Mr. Phillips, come on up to the podium, please. How are you today?
Good.
Good. Mr. Phillips, you had a lawyer appointed to represent you named Ms. Upshaw. Did you ever meet Ms. Upshaw?
No.
Me neither. So Ms. Upshaw is what's called a conflict attorney. She gets involved when we've got three defendants. We've got three defendants in your case. The public defender's office represents one. The conflict defender's office represents Mr. Parks. And then you had the third level of conflict lawyer. They're all good lawyers. It's not who's better than others. It's just they need to not work in the same office, because your defense may involve saying it was Parks who did it, and everything I'm doing is making stuff up. I don't want you saying, yeah, that's what happened, or that's not what happened. I'm just giving you examples. You and your lawyer might decide we need to stick it on Parks. Parks's lawyer may decide we need to stick it on Phillips, and Henderson's lawyer may say, it was those other two guys. So the lawyers need to be independent and not work in the same office. The C3 office has shrunk recently because lawyers have quit. And Ms. Upshaw, who was appointed to represent you, recently resigned. She's not local. I think she's from Middle Georgia, and she is focusing her practice there. So we need to find you another lawyer. It's not your job to find a lawyer. If you can hire one, you can do that. But if you're not able to afford one, you have an absolute right to have a lawyer represent you. And you have very serious charges. There are not more serious charges that you can get than what you're charged with. We are struggling, when I say we, around the state with these C3 lawyers, meaning finding them. So we're working on that. Your case is towards the top of the list because it's serious charges. We have people with shoplifting who don't have a C3 lawyer. But you've been stuck in jail, and we need to get a lawyer on board to represent you in this process. We set this calendar before Ms. Upshaw had resigned, and so I thought she'd be here, and we talk about, hey, do you have discovery? Can we move the case forward? But we can't have that conversation. We need to get that lawyer in place for you. So we're stuck right now. I will bring you back here when we've got that lawyer in place so that I can hear from that lawyer what the plan is for moving forward. Okay?
Yeah.
Do you have questions other than, hey, when is this going to happen? Because if I knew, I'd tell you when. No? Okay. You are wearing an orange jumpsuit. Why are you wearing an orange jumpsuit?
I'm on the underdog compliance dorm.
You're on what?
A compliance dorm.
Compliance dorm? Is that a good thing or a bad thing?
Good.
Good. Excellent. I mean, things are going as well as they can be going there. All right. Good. Oh, okay. Well, good. Well, I appreciate that. And we will do our best to line up this lawyer. Then the prosecutor will get that lawyer the discovery, and we'll figure out what's next. Okay. I will see you soon. Did you all have any questions? Yes, ma'am.
We wanted Mario to get an attorney and have his day in court, but we're fearful of that because he was attacked at jail. He was stabbed over 12 times. He loved having his mom, so they moved him to that part of the jail, I guess, for safekeeping. So my question is, like, how sure are we that the court is going to be able to find a conflict attorney? Because we can't. We're trying, we can't afford an attorney.
Right.
The prices are like so high.
Well, with these charges, they're going to quote you huge figures. This is a case that goes to trial. It's serious stuff. So I hear you, and I want to be real clear. The expectation is not, why don't you go get a lawyer? That's not required. If you cannot afford one for your son, it's your son? Your son, then the state of Georgia has an obligation to get a lawyer for your son. And the state of Georgia is not living up to its obligation right now.
Okay, can you give me contact information for several different I guess, conflict attorneys or resources to point us in that direction?
So it's not your job. You wouldn't be able to call them and say, hey, you need to come take my son's case. It's the state's job to have those attorneys in place. It's sort of like you don't call the public defender's office to say, hey, I'm wondering if you could help me out here. It actually, you get assigned, the public defender gets appointed to a case. And that's not your son in this case, because the public defender, as they explained to me, they went alphabetically. So they took the first person alphabetically, which would be Ms. Henderson, who's seated behind you. And then it went conflict defender and PA Parks rather than PH Phillips. So Phillips got C3, which before the pandemic was not a problem. We had plenty of C3 lawyers and they're great. We just right now we're offering money. I say we, it's not the court's job, but the state system is offering the money. They're having trouble attracting the lawyers to keep the job. So they're working on it and the courts are pressing them on that because your son has a constitutional right. It's not just like, hey, McBurney thinks it's a good idea. That one's not gonna get him anywhere. But the Constitution saying it ought to mean something. So what I can tell you is that there are folks who are real good about bringing lawsuits who are looking at this issue. The fact that your son and several others, if you had been here this morning, you would have heard me say to someone who was pretty darn frustrated, we're looking for a C3 lawyer for you. And so that problem needs to be fixed soon. And if it's not, I think you're going to start reading about it in the newspapers with lawsuits. And that may be what it takes to get people to focus on fixing it. Okay.
How do we, as his parents, find out, or get information about the discovery?
About what?
Discovery.
So discovery flows from the prosecutor to the lawyer for the defendant. Unless you saw that gentleman come out and say, I'm going to represent myself. It goes straight to him. Your son does not want to and should not represent himself. But discovery doesn't go to friends of defendant or parents of defendant. It actually goes to lawyer of defendant. So once your son has that lawyer, you're free to reach out to, let's say the lawyer's name is Fred Smith. You'll be able to reach out to Fred Smith to say, hey, we'd like to see discovery as well. We don't understand how our son is mixed up in this because, and you may have your reasons why. And that lawyer can choose to share it with you, but he's not your lawyer. He is DeMario Phillips' lawyer. Generally, when it's family, the lawyer says, come on to my office and I want to show you all this stuff here, because sometimes the lawyer needs your help to convince your son to take a deal. Again, I'm making things up, but it may be the state says, you know what, Mr. Phillips, you weren't the shooter in this case. You were the driver. We'll offer you 15 years to serve. And your son, who doesn't look like he's a whole lot older than 15, may say, I ain't no way I'm ever going to take that. But the lawyer could share with you the discovery and said, look, here he is on video driving the getaway car. If he goes to trial, his curtains and he'll get life. You all can be very helpful in helping your son understand that there may be some hard decisions to make. I don't know anything about the case. It may be that your son had nothing to do with it, but it is not uncommon for a lawyer to share with family members the discovery. But lawyers also learn, not necessarily you as mom, that there are parents who are bad influences on their kids. Like, don't you take any deal. Well, that lawyer may not want to share things with you because all you're doing is messing things. He or she has your son's best interests in mind in a different way than you do. You love your son, you protect him, you jump in front of a car to save your son's life. Your lawyer is thinking, how can I get the best deal for DeMario Phillips? And the best deal might be 10 years rather than running the risk of life without parole. But mom may not see it that way. And so lawyer may say, mom, I just got to keep you out of the picture. I'm not going to talk with you about the case. I'm not going to give you any discovery because all you're going to do is go intimidate a witness or something. Again, that's not you, but lawyers have to deal with that. So you're going to need to get to know that lawyer, convince the lawyer that you are a positive force in this process. And then that lawyer will say, let's watch the videos together.
We have that kind of report, Eric showing that, but he's not the lawyer anymore.
Right.
He stated to me that when discovery was in, I only had to get he would have to get permission from Mario.
Yeah.
To share that and I.
Yep. So Mr. Cho is with the Public Defender's Office?
Yes.
Yes, he is, but they can't represent your son anymore because they actually briefly represented everyone at initial appearance. He's like, hey, it's nice to meet you. I'm going to move it along. So Mr. Cho is a great guy. And if he had stayed with the case, then Ms. Feely, who is about to talk to me about Ms. Henderson's case, would have been the Eric Cho in your life and would have said, I've talked with your son. He's fine sharing discovery. So that's why we need to get that lawyer in place. And I'm doing what I can in talking with state agencies about the problem in Fulton County with young men sitting in jail with no lawyer. And I'm hoping we can make some progress. You and I aren't going to solve it though, talking about it. Sir, did you have any?
Yeah.
You're welcome.
We spoke with an attorney, Mr. Curtis Hubbard. He came out to the Fulton County jail or whatever, tried to get information on the case and whatever, but there's nothing available for him. I mean, that's what we plan on changing for my son, but he wants to look more into it to see what's going on, but he can't get any information. Probably say it was passed on to the defense, whatever they make by that.
Well, so Mr. Hubbard's great. He actually does know how to get into the public system to see the indictment.
It was never found, and he can't even go to the Fulton County jail to get that. They said it was passed on to the defense, whatever they make by that.
Okay, well, the jail isn't where he'd get that information. And Mr. Hubbard,
I mean, down to.
yeah, to the courthouse. He knows how to work that system and pull up the indictment. And he could always reach out to the prosecutor, and prosecutor might say, look, I'll tell you a little bit about the case. You're not in the case yet, but I can counsel you a little bit on Mr. Phillips's connection to it. But the fact that maybe Mr. Hubbard didn't end up sharing with you everything he learned may be that he's decided it's not something that will work out between you and him. Not on a, like, we're not friends, but on a financial level. I don't know. But it wouldn't be accurate for him to tell you he can't get a copy of the indictment. You could get a copy of the indictment. Just no, very different. But there's no discovery to get yet because there's no lawyer in. Yeah, there's nothing for him to get on that front. Okay. I'm sorry I don't have better news for you, but do know that I take this situation real seriously. Your son has been in for a while. There are young men who've been in twice as long, no lawyer. So we need to get that fixed. Okay. All right. We need to turn to Ms. Henderson. Can you come on up, please? All right. This is the third co-defendant in the case. Ms. Feely, do you have the discovery?
I was hearing about some videos that I need to double check and make sure I have, but in terms of what actually affects Ms. Henderson, I think I've been able to do what I need to.
Okay. Are there any things other than certainly you need to get the pieces you don't have yet? Doesn't sound like it's going to change a whole lot about what you and Ms. Henderson are working through. But beyond that, anything that would prevent this Ms. Henderson's case being trial ready?
So I'll let Mr. Abate speak to in what order he would want to try them. But as the court has noted, she's a minor player in this much larger scenario. And I don't know if the state would want to pursue her limited piece.
We wouldn't. I wouldn't put it on a trial calendar. I just want to know if what I don't want to do is have Mr. Parks and Mr. Phillips ready to go. And then you say, well, you never asked me and I'm not ready because. So I'm asking now, if we woke up tomorrow, Mr. Phillips had that C3 lawyer ready to go. Mr. Cladis surprised us all, ready to go. Would you also be ready to go, assuming you got the videos and had a chance to watch those?
Had Ms. Henderson in the office, yes.
Yeah, okay, all right. I do not see Ms. Henderson's case being the obstacle to trying one or both of the other defendants. I think you agree with that. And I wouldn't ever try Ms. Henderson alone and first. That's not how we do this. Okay. I think we're aligned there. Mr. Abate, anything you want to add about really any of the three defendants?
No, Your Honor, I believe, I know the discovery was served back in February to Ms. Patel. If there's anything that didn't make it into Ms. Lee's file, I'll make sure that I supplement it again, by all means, because I'll just have it drop. I'll probably just research and see.
Yeah, why don't you do that? My guess is that you got the link to Ms. Patel, but if she, I don't know how you pull stuff off the link. If she didn't put it in a shared directory, she may have seen the videos, but they didn't slide over to Ms. Feely. And so if you just do that again, that would be great.
I don't foresee any sort of reason that all three defendants could be tried together if there are any group issues as it pertains to Ms. Henderson and the other two defendants in the next statements. They're on video firing guns.
Okay, got it. Ms. Henderson, do you have any questions about anything we just talked about?
No, sir.
All right, so you're out on bond, unlike Mr. Parks or Mr. Phillips. I don't know the conditions of your bond, but make sure you continue to comply with them, okay?
Yes, sir.
And that may well include no contact with Mr. Parks and his family, Mr. Phillips and his family, whatever those are, maintain those conditions. And we'll get you back here when we're able to move Mr. Parks and Mr. Phillips's cases along. Ms. Feely, anything else?
No.
All right.
Your Honor, that's all the cases I have in the calendar. Rest of the afternoon, I'll be excused.
Yes, sir. Thanks for your time.
Thank you, Judge Shaw.
You too. Wait, don't go yet.
Mr. Dill?
Oh, all right. Crystal Ball Abate. All right, Mr. Dill is next. Is he in custody?
He is in Department of Corrections custody, Your Honor.
He is in custody, just not here.
That's correct. His mother is here, I believe, still. Just she wanted to
Great.
hear what the announcement was.
Well, it's a status conference, so I was going to start with you. It says Ms. Primovic, but it's your case now. So I'm going to actually start with a couple questions. Mr. Dill is in DOC custody for what and for how long, as best you know?
So it looks like at least probation, and he's at Jackson, like just still at the diagnostic, and I'm not sure why. And so I've been speaking with his mother about that. He's got a max out date of March 3rd, 2024.
Okay.
And there was no decision on the tentative enrollment website to suggest that it might be sooner than that.
Okay. But it's not a long window. I mean, it could go through 2024, but he's not in for a 25-year no parole sentence or anything.
Right, he should come back to Rice Street.
Okay. And is he in a no bond status here?
I know he went straight from.
I'll double check, Judge, but I do remember when he was last on the calendar.
He has no bond. Some Judge Oliver said no bond when it was a CP number. Not quite sure how she was hearing a murder case. And there's been nothing since then. So, and Ms. Feely has entered an appearance. Great. Or substituted counsel. So how about discovery? Or this is again why you're waiting to hear from the state?
So I have what appears to be some stuff in my file. I'm not, because I haven't had occasion to go out to visit Mr. Dill yet. I haven't gone through everything, but I'm happy to do that and just make sure that I can let the state know what else I need.
Okay. So the scheduling order was entered. It may have been, I don't remember when you started with us, but the scheduling order was entered in April. And it had some trigger dates like a motions deadline. And then we've now got this status hearing, which is when we decide, hey, can we put this on a trial calendar? I guess I'm a little confused. I know you've inherited a lot, but I don't know what you're waiting for to talk with Mr. Dill or make sure you've got all the discovery, because I'll hear from Mr. Thomas in just a minute, but I want to get this on a trial calendar.
Sure, and I think that timing is particularly problematic because I don't know when Ms. Patel's last day was, but I think it was around that time. And then my start date was the middle of May. But
So this hit the gap
I believe it
when Ms. Wood had everything.
And Mr. Dill has not been in Fulton County since that I've had the case.
Okay.
So I still need to make that happen as well.
Mr. Thomas, first question, will this become Mr. Whitenauer's? Are you keeping anything from here or it's a clean break? You're going where you're going? All right, so this will be Mr. Whitenauer's case in 9 hours, whenever it is. What do you want to add to what we've been discussing?
So yes, there was a discovery order. Discovery was served in regards to that order. There was only one issue with that discovery. There's an autopsy report that we still don't have. At that time, we didn't serve a report, we served a request showing that we requested it. I know from other cases that the medical examiner is as backed up as we are. I have older murder cases where I still don't have an autopsy report, we're trying to get it. We just don't have it yet.
So does that mean there's been no autopsy or they did it, they just haven't refined it to a report?
Yes, sir, they did the autopsy.
Okay.
Yeah,
It would seem like the problems would develop if you waited 6 months to do the autopsy.
yes, sir, so they done an autopsy, it's just that producing the report, that's what's being backed up.
Okay.
So that's the only outstanding discovery, everything else was served. And Ms. Feely, I can reserve everything to you, just make sure you have everything. And then we'll just go from there, but that is everything outside of that.
Is there anything about the case with which you're familiar that would make you think that the autopsy report is going to be the decider? The allegation is that Mr. Dill shot Mr. Stafford. So I'm assuming Mr. Stafford died because there's a hole in his head or in his heart or his liver or something. Or is this one where the autopsy report may be along the lines of the Rooks trial, where the cause of death was more complicated and it was a neglect situation rather than an affirmative action?
So I don't anticipate the autopsy report being anything like groundbreaking. I'm not gonna say what I think it's gonna say, but I anticipate it's gonna just confirm that he died from the shots.
Okay. It was not an accidental death or anything like that. Okay. Certainly, everyone's entitled to that autopsy report. You can't get it, Ms. Feely, till it's done. So my direction then to you, Mr. Thomas, is to make sure that Mr. Whitenauer reserves discovery on Ms. Feely, everything that you've got, and then we'll just know that the autopsy report's not out there. Is there a expedite flag for the ME's office like there is for the GBI, where if Mr. Dill's case were put on a trial calendar in October, and I'm not saying that would happen, but if it were, that you all will be able to reach out saying, it's not going to be helpful to get the autopsy in December because we're going to have the coroner on the stand in October?
Yes, sir. I don't know personally if there's a specific flag, but that does give us more ammunition to be like, hey, we need to push this up because we got trial.
You're going to have nothing to refer to when you testify. Okay, got it. Apart from the missing the incomplete autopsy report, anything that you would want to get before you would say, let's try the case?
So going through the file, that's the only thing I can see on the autopsy report.
Okay.
As far as everything else was served back in May.
So Mr. Dill was granted parole in August and he got revoked for these allegations is why he's in. Okay. So it was a parole revocation.
Absence from Fulton County does pose a challenge in terms of preparation as well.
Oh, no doubt. We would bring him back. If he's going to be on a trial calendar, we need to get him back here and we would just do an early order of production for the trial date. I'm also happy to help set up if you haven't. Before the pandemic, we had gotten installed in your office a special direct line DOC type. It's like a bat phone, but it's DOC, where you can have secure communications with DOC inmates. and they have the receiving line at almost every facility in the DOC stable of facility. There might be a county jail that holds DOC people where they don't have it, but anything that was a state something, you could have, and it wasn't, I keep holding up a phone. It was like a WebEx type thing where you could have a communication. And it's not face to face, but at least it's a way to start developing a connection with Mr. Dill. So if that's news to you, you should ask around because we paid to get it installed. And otherwise, we'll just need to get Mr. Dill here a little in advance of his trial. Okay. All right. So it sounds like no motions. You'll reserve the discovery and we'll hope they get that autopsy out soon. Terry Spence. Oh, that's Mr. Cladis. Don't necessarily bring him out. What did he say about Terry Spence? Ms. Charles, Mr. Cladis nudges you under the bus a little bit. I don't have body cameras, no 911 calls. You're on vacation. He says you're on vacation. You were, where'd you go?
Guadalupe.
Wow. But then he's confident it'll get squared away once you're both back in the office.
And it did. I go back on July 31st. On August 1st, I sent him the link. He's out until August 9th.
Yep.
And I sent him an email. And once he gets back, we'll try and work through it.
So his link will have those body cams, whatever you've got, he will have.
I said.
Okay.
9 videos.
9 videos. So really no reason we can't move this to a trial calendar because he'll have what he needs. Excellent. Can we bring Mr. Spence just to the door? Thank you. Mr. Smith, your client is up next.
Very exciting, Your Honor.
Glad you're still with us. It's got 2 cases. Then we have a David Cooper special. Hey, Mr. Spence, how are you? Not so great. Okay, well, I'm sorry to hear that. That's somewhat of a tricky question to ask someone who's coming from jail anyway. I just want to give you an update on your case. Your lawyer, Mr. Cladis, wasn't available to be here today. He had a conflict, but he reports that there were a few pieces of discovery that he didn't have from the district attorney's office, a couple videos and a 911 call. The district attorney's office has provided that. So Mr. Cladis is going to review that discovery. He's going to come talk to you about it. He may even get me to sign an order that lets him bring in a computer so you and he can sit there and watch the videos so you can see what the evidence is that the state has. And you and Mr. Cladis can talk about as good evidence, that's weak evidence or whatever. And we're going to get your case on a trial calendar coming up soon. So either you can have a trial if you and Mr. Cladis think that's the best way to resolve your case, or before then, you can work your case out with some kind of plea. But I didn't want to skip you today, even though Mr. Cladis couldn't be here. I just want to let you know what's going on with your case. Do you have any questions for me? I can only talk about process. I don't know the facts of your case. That's for you and Mr. Cladis.
I actually really need some help. But I was on my medication and I had a death in my family, like I told you. And,
yeah.
And there's I'm trying to like get in a program and stuff like that so that they help me because we all did 2 different programs. If he would have been here today, I could have gave him. I don't even have his address. If I had his address, I could have sent it to him through there.
Well, he has your address, so why don't I do this? I'm making a list of notes that I'm gonna give him. So these will be notes from the judge. And I will tell him that he needs to come see you because there's some materials you want to share with him about programs. That's going to be helpful for him because if he is trying to negotiate with the prosecutor, it's always useful to be able to say, well, we don't want you to just cut my guy a break. Here's a program he could go do. In fact, Mr. Spence found that program. That shows you're motivated and interested in that. So I'll make sure Mr. Cladis knows that you're particularly anxious to see him. You can talk to him about the medication situation as well. I'll get you back here so we can either, like I said, work your case out, or if what you and Mr. Cladis decide is you want your trial, then I'll make sure you get that jury. Okay? All right. It's good seeing you.
That's what we got at Parks.
I can talk to Parks for 2 seconds. I don't have a whole lot to tell him, but if he was saying he wanted to talk, just bring him the same way we just did. Then we will do Mr. Rhodes.
Did he leave? That guy with the glasses? He left?
What? No, he better not have left. Jason Sherman? I know how to fix that one. He's got 2 ankle monitors on. He's got to be findable. Okay.
Thank you.
I thought you guys could like press a button and the ankle monitors would start going, woo, exactly. Freeze them up. Hey, you can stand right there. Mr. Parks.
Yeah.
I'm Judge McBurney. How you doing?
Good.
I didn't mean to ignore you today. Your lawyer had a conflict, and so he couldn't be here today. So I got the updates, but the deputy said, hey, you might as well tell Mr. Parks the update. So the prosecutor's already left the room, but he is getting your lawyer, Mr. Cladis, a couple pieces of discovery that hadn't been transferred. You had a different conflict defender originally, a guy named Mr. Terry. And his cases went to Mr. Cladis. But when Mr. Terry was handing the folder over, not everything went to Mr. Cladis. So he let me know, hey, there are a few things I'm missing. The prosecutor now knows that he's getting that to Mr. Cladis. And then he'll come see you to talk about everything he got in the discovery to figure out what's next with your case. My goal is to get you and Mr. Phillips and in theory, Ms. Henderson, I don't know if she'll go to trial with you, get you your trial at the end of this summer or early fall. Assuming you want a trial, it may be you and Mr. Cladis try to work the case out. I don't get in the middle of that. Today's goal was to make sure your lawyer had everything he needed to get ready either for trial or a plea. And he shared with me what was missing. The state said they'll get it, and Cladis will come see you, and we'll figure out what we're going to do. Okay?
Yeah.
All right. Did he leave?
Yes, sir.
Okay. I guess we're not done. He could always make it back.
Judge, I sent a text message to the number that he left on here, so.
Okay.
But it is a conflict. I did discover that.
Okay. What is the nature of the conflict?
So there's a number of open cases on Odyssey between Mr. Sherman and the complaining witness. It looks like they're cross defendants.
Okay.
And we
His
had-
brother.
Yes.
Yeah.
And we had the complaining witness.
Okay.
I just sent a text message.
All right. Well, let's turn to Mr. Rhodes, positions 6 and 7. Mr. Rhodes, can you turn your screen on, please? Can you hear me, Mr. Rhodes?
Yes.
Great. All right, we've got you in the spotlight, and we've got Mr. Smith, your lawyer, in the spotlight. you've got two cases. One of them is a criminal damage to property case, and the other is an aggravated assault case. You allegedly shot at a couple people. Mr. Smith, no motions were filed. It says to me you got discovery and didn't find anything you thought should be suppressed. Is that correct?
That's correct, Your Honor.
Okay. Anything standing between you and your client and me setting this down for trial?
No, Your Honor.
Okay. Ms. Charles, you've got both these cases?
I do, Your Honor.
Is the state ready to have these two cases moved to a trial calendar?
Just the one case, I think Mr. Smith, yesterday, there's one case of believing based on victim. We may not be able to proceed on. The second one, of working for the second witness in the case. I told Mr. Smith I was setting up the once I figure out how we're going to proceed.
Ms. Charles is hard to hear.
Oh.
Yeah, that'd be because the microphone wasn't on.
Sorry. So as Mr. Smith can confirm, on the case ending 205, the criminal damage case, it is likely based on our conversations with the victim. She's the victim in both cases. We may not proceed with that case. We have a recanting victim and she's saying something different than what she already said. But there is a witness in the aggravated assault case what I'm trying to track down to see if I could perhaps still keep that case going despite the primary victim's current statements.
Okay.
So I'm working through that piece. And Mr. Rhodes also has this CP case.
How's Mr. Rhodes still on bond? What's his CP case number?
It is 21 CP 205-217. And there's a gang component to that case as well. It's unindicted.
Okay. Well, I think I followed what you said. So, Mr. Smith, as I understand it, the state may not move forward in the end with the case ending in 205. In the case ending in 233, they may be having a witness location issue. I hear that. My response to that is not Mr. Rhodes' problem. And so my thought is we still move this to a trial calendar. It's not next week. It'll be a trial calendar in probably October at the earliest, but I think we need to move it there, and the state will do what it can to move forward. It may involve expediting the unindicted gang case, but for now, the only two cases I've got, and the only ones I need for Mr. Rhodes, sound like they are trial ready, but they may not result in trials.
Yes.
Okay, all right. Mr. Smith, anything you want to add on behalf of Mr. Rhodes?
No, Your Honor.
Okay. Mr. Rhodes, do you have any questions?
No, sir.
All right. Then you all are excused. Thank you for being here.
Thank you, Your Honor. Have a great weekend.
Well, by process of elimination, that leaves us with Mr. Cooper and Mr. Rosner.
Good to see you, Judge.
How are you there?
Doing well. It's like old times, Friday afternoons with Judge McBurney.
You make it sound so fun.
It's exactly how I remember.
Well, except you're at home and I'm not, so.
There is that, yes.
So we've got sort of like Mr. Rhodes, a case that's on the status conference calendar, no particularized motions filed, nothing flagged about missing discovery. How are things going on the trial preparation side, Mr. Cooper? Is that where this case ought to go?
I'll let Mr. Thomas make an announcement, Judge.
So yes, Your Honor. So going through this case and talking with the victim, I am going to submit this case to the adult diversion program. It seems like this case will be right for it. It seems like Mr. Rosner will be a good candidate for it. There's some stuff I had to do behind the scenes before I submitted it. So that hasn't been submitted yet, but I do anticipate that submission either today or Monday. And then from there, it takes about 7 days to get a response.
There is an unindicted case. Is it the same case? It says companion case on my calendar, or is it just the CP that yielded the indictment? It could just be a misnomer.
Excuse me, Your Honor.
It's a CP judge that provides the basis for the lead charge on the indictment now.
So the CP case is an aggravated stalking case. It lists David Jones, not David Cooper, as the lawyer.
Yes, Judge. So there were two CP cases. The original CP case, it was the first charge. The second CP case, that is the ag stalking. That first CP case rolled into the SC when it got indicted, and that left the second CP case just lingering out there. It's closed, but it didn't get combined into the SC case with the other CP.
Okay, so if and when the indicted case gets resolved, we need to make sure that that other CP thing is extinguished in some way so it doesn't keep popping up for Mr. Rosner.
Correct. And as far as I can see, pulling it up in Odyssey, it's showing up as closed. I don't know if there needs to be an NPGJ that goes with that or something along those lines, just to clarify, but I do see that as closed in Odyssey.
Yep, I see that too. And there's a disposition entry, and it's interesting. There's a bind over that links to this indictment, but okay, well, it's not open. That's all I needed to know. So I'll cross that out. Mr. Thomas, what's the time frame for you or Mr. Whitenauer to get to Ms. Nelson order moving this to the dead docket or to judicial hold?
So Your Honor, once submitted, it takes about 7 days to get an answer. So we should have an answer the week of the 15th of August.
Okay. I want this to have a landing place. Do we put it on a trial calendar or do we not clog the trial calendar and put this on an inquiry calendar 3 weeks out, and it would come off it if the pretrial diversion has been approved?
Your Honor, this may be more appropriate for an inquiry calendar.
Mr. Cooper, does that work for you?
That's fine, Judge. This is a fairly new process for me. I come from the days of the PTIs and virtual PTIs. There being a structured program is novel.
It is, and it is a go-to move for Mr. Thomas. He is, I think this will be his third DA PTD for one of his cases in just a couple weeks. But it makes sense if it's a one-off, as in a couple of his cases have been. I'm remembering a little more about this case as I looked at Mr. Rosner's bond and seeing Ms. Finney's name. I now remember a little bit more what this one was all about. It sounds like Mr. Rosner's been complying with his bond because we're here talking and he's not in custody. So hopefully that'll keep up. And we'll just put this on an inquiry calendar towards the end of August. It will come off that calendar if the pretrial diversion has been entered.
And Judge, we had filed about a month ago a motion to modify bond to remove the ankle monitor. I don't know. My assumption is that if the diversion goes through, that puts the case on judicial hold, like how it used to be. So I don't know if it would be more practical to do the order modifying the bond to remove the ankle monitor now, to clarify that so that he's not showing up with the, hey, my case got sent to diversion, I don't need this ankle monitor anymore, and that causing any confusion.
So what I would ask you to do, Mr. Cooper, is remind Ms. Nelson of the motion to modify the bond. And is there I got it right here. Did you include a proposed order?
I believe
So what you can do is submit a proposed order that would modify Mr. Rosner's bond to the limited extent of removing that ankle monitor after he's been accepted into pretrial diversion. I'm not going to modify anything until we know that that actually works out. It's not ultimately Mr. Thomas's decision. He recommends it, and then different set of folks in the DA's office decide if it's the right fit. And if it is the right fit, I think it would make a ton of sense for Mr. Rosner to go through that diversion without the ankle monitor on his ankle.
Sure. So I did include a proposed order when I sent that motion over, but I'll go ahead and edit that and get that sent back over to the court.
Okay, whatever's in Odyssey, your July 6th motion for a modification of bond does not have a proposed order. So it doesn't mean you didn't send it to someone else. I don't have it. So.
Right, I sent that attached to the email that I sent to Ms. Nelson. Along with a courtesy copy of that motion that I filed.
Great. And she may well have sent it to me. I don't have it anymore. So hold off until your client gets in. If he gets in, resend.
All right. And I'll follow up with, will it be Mr. Thomas or Mr. Whitenauer going forward here?
So Your Honor, I will carry this case to submission to the adult diversion program. I think that'll make sense. If for some reason it gets kicked back, then it will go to Mr. Whitenauer. So how will Mr. Cooper or Mr. Rosner know if Mr. Rosner was accepted into the program? So I'll get an email, and whatever that email says, I'll forward to Mr. Cooper. Okay. So Mr. Cooper, it sounds like if all goes well, you still deal with Mr. Thomas. If things go poorly, then you get the Whitenauer treatment.
That's good to know, Judge. I'll hope to continue working with Mr. Thomas here.
All right, we'll see what happens. Mr. Rosner, do you have any questions about anything we've discussed?
I do not.
Okay, then I think we've got a plan. Just keep us posted, Mr. Thomas.
Thank you, Your Honor.
All right, that is it, except for Mr. Porter and whether we're going to do the Ferretta hearing today.
All right, Judge. Well, it was very good to see you again, and please let me know if you have any exciting new business opportunities there with your conflict cases.
So I actually tried calling the number on your funky business card and it didn't work. Did you change your number, or is there just something weird for a couple of days?
I'd certainly hope that my number would work, the 404-913-3367.
I don't know what it says. It's on the business card that I have in my office. But
I did just get a new phone, so who knows?
Who knows? This would have been a few weeks ago. I am working with Gactyl to try to help address this C3 situation.
Are you talking with Maisie Lynn?
Oh, yes.
Okay, cool.
Maisie Lynn, Jill, and the big kahuna himself, Sheffield.
Oh, Sheffield. Okay, cool. We definitely have interest in helping out. So
good. Well, we'd be offering top dollar, so we could make it in your interest.
Hey, yeah, give us something good, and we'll have me and Dennis and Leah and Euphemia and Linda and.
See, that's beautiful. That's like the big reunion. You can bring homemade marshmallows. It'll be good.
Right, absolutely. Get the whole gang back together.
All right.
All right. Take care, Judge. Good to see you.
Bye.
Bye.
All right. Thank you, Your Honor. May I be excused?
You may. So we got two loose ends. Mr. Sherman, Jason Sherman, and my thought is we do a bench warrant. And then we've got Mr. Porter, and my thought is that we bring Mr. Porter back on another date for his Ferretta hearing. So just tell him we're not able to fit it in. Thank you.
All right, thank you, Your Honor. It's been a pleasure.
Yes. So let me just replay this. So Mr. Shapiro, you will be handling sex crimes with child victims.
That's correct, Judge.
Mr. Whitenauer will be handling DV cases. And Mr. Brown will be handling sex crimes with adult victims.
That's correct, Your Honor.
I mean, Seth Brown has been assigned here. I don't know what unit he's in, but I don't think there's another way you all sliced up CWAC. It's those three. There's DV, crimes against children, crimes against non-children. And that Seth Brown would have to do that. Otherwise, he's taken Whitenauer or Shapiro's job.
Judge, Seth Brown is going to be handling the sexual assault unit cases in your courtroom, but just he'll only be doing that for 30 days because he said that's all that he could stand with honor, and we'll find another ADA to come in there, but he's only going to be there in temporary, Judge.
Interesting. I didn't realize it was a temporary assignment. They're just testing his pain threshold.
That's it. That's it, Judge. No, I mean, the truth is, so I'm being moved, coming Monday, and then Seth Brown and Marshall Hodge here in SAU are going to be moved in 30 days. So they're just kind of going to be covering on some courtrooms during that time.
Who will be the, whatever you called it, sexual assault prosecutor in here in November?
That I have not been told. So I don't have.
Huh. Okay, nothing like continuity. Well, good. So are you at least staying at DV, or are you also a 30-day, I'm filling in for someone?
I mean, latest and greatest is I am assigned to DV for your courtroom, Dunaway and Whitaker.
Okay. That's not a bad draw. Okay. Well, good. And where are you going, Mr. Thomas?
So I'm on the sexual assault. So me and John are switching.
So could you end up here, or do you know where you're going?
Yeah, so I'm going to have different programs. I can't say off the top of my head, but I have different.
You might want to learn them if you're starting tomorrow. Yeah, just thought. Okay. Well, great. These are the public defenders assigned to this courtroom. Work with them. And who knows who will be the new Miss Charles? It's still Friday. It's all 3:30. Still no news?
No news yet.
Okay. All right. And where are you going? Which of the units? Well, but that's three different. Which of the three? Okay. So you'll be working with Mr. Thomas and others. Okay. Interesting. Okay. All right. Thank you, everyone. Have a good weekend.
Thank you, Judge.
Thanks, Ms. Rivers.
Thank you, Judge. Have a great weekend.